Petition stands dismissed as devoid of merit.
Right. Order. Yes.
The substantial issue framed by this courts is answered negative, and the appeal is devoid of merit. Accordingly, the same stands dismissed. Appeal- 180 or 10. Both MSA Bill 180 2019 and 10 2019. Both the appeals stand dismissed.
35 and 36.
Both CRP 284 2024 and 180 2024. Both the revision petitions stand dismissed.
Deeply alleged.
Supplementary. Yes.
Yeah, please, your lordship. Item 30,
1 3
30.
3. Yes, 30.
30. My lord, in this matter, what happened, my lord? It should go to the division bench. Because, my lord, there is latest notification.
So, on what basis you are saying that this?
My lord, common judgment. Some are lifer, some are below 10. So, the four appeals were filed. Initially, my lord, the joint appeal was filed. Then, my lord, individual was filed, my lord, in single bench and division bench. Then, my lord, this matter came up before the single bench, and single bench argued for long on the issue of DB or single. Then, my lord, is come to the conclusion that it should go to the division bench, being common judgment. Interpretation maybe if goes contradicting of appreciation of evidences, so different judgment may come the same from the same impugned judgment. So only it should go to the division bench.
Otherwise, basically, the case was of which nature? It was a
My lord, till then
case of murder or 376 or what is?
My lord, 302 also. My lord.
302 was
Two
also
also.
there.
Some are life imprisonment.
Ah.
Some are 8 years, 5 years. So initially, common appeal was filed. Then, my lord, the division bench observation that it is doubtful whether it can be filed before the division bench. All should go division bench.
Acha, acha. Yes, yes.
Then, my lord,
What
bench.
you can go through this one notification.
It should go to the division bench, my lord, and
So here, in this case, what was the quantum of your sentence?
my lord, 8 years.
8 years.
And others lifer. So life imprisonments are pending in the division bench.
Obviously.
Yes, my lord. And so, my lord, this should go also division bench because the same set of evidences may be appreciated differently, and maybe
State
come
trial
up.
court judgment.
Yes, madam.
And divorce notice.
It was a petition for parole, my lord. Mother expired suddenly, my lord. So it is pending because of this thing for long, my lord, because of all these situations. Many times listed but could not be decided, my lord.
Oh.
It was division bench, my lord.
So it is, I was filed by you.
Yes, ma'am.
And the appeal was filed by one senior counsel is there,
My
Mr.
lord,
B.D.
now it is under me, my lord. Taken by me.
You are
Yes.
taking now. Okay. Hard Mr. A.K. Taluk, done counsel appearing 30 for the applicant. And it is submitted by him, and also heard Mr. P. Botaku. It is submitted by her in pursuant to notification.
As per notification, my lord.
Pursuant to notification dated 3/2/2026. The matter ought to have been tried by. No, it
But to have been listed hard by division bench. For what to have been listed before the division bench, my lord.
be listed before the division bench. Mr. Bott also raised no objection to that regard. In view of the notification above referred notification, the case being be transferred before the division bench for hearing of the case. Is there any other appeal? Is there any?
Yes, my lord. There are other appeals pending, my lord, but not connection because I have only, my lord, parole matter only. Now it's only parole matter.
Parole matter means your entire appeal will go now.
No, my lord. The others will go, my lord. But I am in this one only, my lord. 168. Criminal appeal 168. I am in this. So others will go, but I do not have the numbers and all this.
No, now your entire the appeal and application both will go now.
Yes.
Uh-huh.
Yes.
No, I'm asking, do you have the number of the division bench? Any number? How many appeals are being now filed before the division bench? Only
Lord,
one, or there are two, three?
One division bench matters and two single bench matters.
No, single bench we are not connected. Division bench cannot tell us the division bench number.
My number I cannot say this stage,
okay.
my lord.
Okay. List accordingly before the appropriate bench. The registry will do the need. Okay, then you just play.
My lord, can a date be fixed, my lord? Parole matter.
Date. So how can we fix the date?
Division bench is sitting otherwise, my lord.
Do one thing. We are just asking for listed before the division bench. You immediately approach the registry. Just try to find out the number also and the division bench matter also. In that case, you can pray for it. Oh, sorry, 30. 31 is which HR Chaudhary was. I had only 31 to Tamil Lewis and Kunel Lewis. 31 I can like koi do karo. I যাব এইটো নিশ্চয় যেটো বিধি এইটো তেওঁৱে লোৱা বুলি কয় both are take. Let both the matters be. Mr. Chowdhury, 31 is also connected matter. So
yes,
you are appearing in 31 also.
No, my lord. It is only because of LCR it has come. LCR was called for in that case. It is attached with that case. Only for this. I asked the registry why this has come. They said the LCR is with this. That's why we are getting it. I am not connected.
No, you are not appearing in 31.
No, my lord.
But 31 is otherwise connected with the out of
yes, my lord, because of the common LCR.
And yes, whatever out of same judgment.
Same
trial. Okay. Both will go there.
Yes.
Yes.
Lordship, I pray for an accommodation in item 27 for today, Lord. Can kindly be taken up after a week. I have informed the respondent side.
Otherwise, you are for the appellant.
Yes.
with the consent of the others, litigant counsel for the management, setting the inconvenience on the part of the and discuss. Prayer allowed, please the matter accordingly. After 2 weeks, we cannot fix a date here. 2 weeks will do.
After a week, then
After a week. After a week, as an
much obliged.
Maybe. Item number 18, Lordship, 1-8.
yes.
Lordship. As per information, charge sheet submitted, Lordship.
Charge sheet is already submitted.
Submit.
Yes, what is the CS number?
CS number 160/25 dated 30/11/25.
Are you on interim there?
Interim, Lordship.
Interim was there.
Yes.
Interim to 15 days will extend kori out. So we are extending your interim till 15 days.
Yes.
Up to 15 days, we are extending your interim. Within that period, you have appeared before the learned trial court below with an appropriate application for bail.
Problem.
My lord, I beg to mention item number 20 of today's list, my lord. CD has come, but my learned senior Mr. Angshuman Bora is out of station. Let the matter be taken up next week, my lord. Immediate.
Otherwise, we have
CD
received.
received.
You are Mr. A. Hussain.
R. Islam.
R. Islam. Or Mr. R. Islam appearing on behalf of Mr. A. M. Bora, the learned senior advocate, stated that and paid for an item stating that Mr. Bora is out of station. However, Mr. Bora has submitted that CD is already received. Let the CD be retained till next date of listing when it can be listed.
On 18/2.
18. You
Much
are,
obliged.
is there any interim was there?
Yes, interim order.
Interim be continued till next date.
Much. CD may be retained here, my lord.
Yes, we are retaining.
Much obliged.
My lord, so far this matter is concerned, I have another matter in court number 22 and I have made a submission there because the record of the case is there lying there. It's an out of the same FIR.
When it is fixed here or under court.
His lordship has passed an order, send it to this honorable court, and lordship may take it at proof. In the meantime, it will come up.
But I'm just not following. I'm not following you. What I'm saying?
We have analogous matter out
Ah.
of the same FIR. It is pending before the court number 22.
Ah.
Now,
So
the
you want to send it to court number 22
No, no.
or?
He has passed an order
Acha,
to
okay.
transfer it before your lordships. So it will be-
Record is still there.
the record is there.
Can you do this, please?
So let it come at 2 p.m. My lord. Your lordship may take it.
Mr. Botakur, yes.
Recorded is there.
2
then
p.m. No, 2 p.m. because 2 p.m. two matters have been fixed. That has to be heard.
Yes,
So this bench will only up to 1.
up to 1 only.
Yes, only up to 1.
If it comes in the meantime, otherwise tomorrow.
That to পাৰিব নেকি আমি তেওঁলোকৰ তাতহে আছে তেওঁলোকৰ কমিটি খিনি কৰিব লাগিব আজি নকৰাই ভাল নেকি দিগদাৰ হ'ব। তাতো আমি নোৱাৰো ন। Mr. Botakur is saying that there are some formalities. It has to go from there to office, then again it has to be
yes,
listed, then will come here. So I don't know by one, if it comes and okay, then if it doesn't come, most probably by tomorrow or day after tomorrow, it can be otherwise. We're listing it to tomorrow then?
Tomorrow, okay.
Tomorrow, because if it reaches by 1, it's okay,
Yeah, I
otherwise it may
understand.
not reach it. আৰু মই কিবা লিখিব লাগিব সেই ৰেকৰ্ডটো তাত লিখিলে পাই যাব নে?
With that. AB. AB to
Your lordship may simply adjourn the matter because the order is already passed in that case. Automatically that matter will be taken. The number to
What
Then
else
in that
will
case you take information. If it is there in the office, then
then it may be kindly take with AB number 2873 of
acha, AB number
2873 of 2025.
2873 of 2020.
Smile.
কালিৰ কাৰণে লিষ্ট কৰি দিয়ক মৰৰ লিষ্ট কৰি দিয়ক AB 2873 of 2020.
Obliged, ma'am. I'm grateful to my learned friend also.
Applicable. Lordship, this is in regular bail application, Lordship. FIR is at case number 10, Lordship. Lordship, yesterday already the co-accused are granted bail by this honorable court, Lordship.
No, granted money,
Bail,
we are on some
interim bail.
conditions.
Interim bail, Lordship.
Interim bill on condition
same-
that they're
same-
going to appear.
Yes,
Your
Lordship.
petitioner is also going to appear.
Yes, Lordship, I have.
How the order will pass today, how he will appear tomorrow, I don't know. How he will appear? Don't take a chance.
Because, Lordship, I have
Would you
also.
file your bail application yesterday or day before yesterday, then the matter would have been different. But tomorrow, from tomorrow, how
Lordship,
can be possible?
on Saturday, I have mentioned for listing for Monday,
Ah,
but it is come today, Lordship.
that is up to you. How it is possible? Will it be possible? Will it be possible on your part? The order will be there, it will be signed, will be certified copy, then it will be sent to the jail authority. How it can be arranged? There has to be some arrangement, na?
Yes, Lordship.
And your petitioner, he has books with him? He brought the books with him in the jail area? Inside the jail, whether he brought all his books? How he will appear?
Some arrangement for today, tomorrow, Lordship. Some arrangement will done as per the information, Lordship.
Ah.
By from the jail, Lordship.
No, we are giving interim. We are not that. Itu jail আছিল নেকি কোনটো কেছত এটা কেছত jail আছিল
yesterday one item number page 28
দুটা matter হৈছিলে অ 12 নম্বৰটো বেলে 12 নম্বৰ আইটেমৰ কথা কৈছে এইটো বা কোনটো কেছ সেই অংকুৰ শংকুৰ এইকেইটা ন 11 ফেব্ৰুৱাৰীৰ পৰা আৰম্ভ হ'ব
item number
এইকেইটাক ইন্টাৰিম দিয়া গৈছে
yesterday's item number
এটা ইন্টাৰিম এইটো বেলেগ এনেকৈ লৈ থৈ যি কৰে কৰিব
Lordship, I have also annexed the schedule of
no whatever how will you appear my question is how will you appear by doing all the formalities it will be night only
if Lordship.
Because bail bond, we are not going to accept your bail bond. It will be again, it has to be before the CGM.
If Lordship.
Golaghat.
If Lordship may make it available.
Huh?
Make it available by 1. If some possible is there, Lordship.
It order might tell you. What is your name?
Lordship. Monjil Dotto.
Monjit.
Monjil Dotto, petitioner.
The accused number?
Accused number 1 in FIR is Lordship accused number 1. Forwarding report.
According to accused number 1. Okay.
matter speaks on 26 too
26.
Obliged, Lordship.
You granted you do necessary arrangement.
If Lordship possible.
That I cannot say. You are busy with some other books. 26. It order my report.
May I please the Lord? The anticipatory bill, my lord. Here, my lord, what happened, my lord? Page 23, kindly peruse, my lord.
Page?
23, my lord. Here, accused petitioner before your lordship has received a summon from the learned SCGM court, my lord, where, my lord, during the filing the charge sheet, my lord, section 96 has been added, my lord. And the 96, the SCGM court doesn't have the, my lord, authority, my lord, session, it is session triable. Like if he appears, my lord, he will be taken into custody, my lord. That's why, my lord, I have filed this petition, my lord, for protection, my lord, for appearance, my lord, appearance bill.
Yeah.
Search sheet submitted, he is shown as absconder.
Absconder.
Has it already completed, my lord? The trial already has been begun, my lord.
Why you are absconding at that time?
My lord, I have not absconded, my lord. I am resided in my permanent residence, my lord. They have, although this warrant has been issued, my lord, if I have my lord, absconded, my lord, they should issue a proclamation, my lord. There is no such order has been passed, my lord, for any proclamation and all, my lord.
No, rightly, wrongly, whatever,
My
the
lord,
police filed
no,
charges showing you
yes,
as an
that
absconder.
is
So
true,
you
my
are
lord.
now you are receiving summons only,
My lord, I am
not
receiving.
the warrant. Right?
No, my lord, no. My
That's what I'm saying.
Right.
Now, why you have not cooperated in the investigation? You were absconding.
My lord, yes, that is true, my lord. I have not received any notice and all, my lord, for during the investigation for cooperation, my lord. Although they have shown in the charge sheet, my lord.
Yeah. This was earlier 366A, I think,
Yes. Now it's 96.
96.
90. My lord, procreation of child, my lord.
Yes, yes. Yes, what happened?
No, while someone says issued already, my lord, regarding.
Yes, only some. 10, 15 days we can at best. Thereafter we can. Because there is nothing before us whether how the child was procured and what was the age,
Yes.
the time,
Yes.
what kind of
Yes.
how she was even if she was sexually assaulted or not. These are not before us.
Yes.
You are Mr.
Well, as Hazarika.
S. Hazarika. And Mr. S. Hazarika, the learned counsel for business. And also had Mr. B. Bota for the learned additional PP appearing on behalf of students. This is an application section so and so in connection with so and so. It is submitted by Mr. Hazarika that the present accused petitioner is innocent. He has not connected with the alleged offense. Further, he is the permanent resident of his address locality, and during the entire investigation, he never received any notice of summon from the IO, nor he was searched by police during the investigation. He was not aware about his laws against him, and at the stage when the summons were issued by the court, then only he came to know about the case. However, the accused petitioner is ready and willing to appear before the learned trial court below and to contest the case if he is provided with the privilege of pre-arrest. Next one, Mr. Waterford, the learned additional PP submitted in this report that apart from the other section, the case is also charged under section 96 BNS, and at present only summons been issued against the present petition. He was also shown as an absconder in the charge sheet as he never cooperated in the investigation. However, some interim protection may be provided with a direction to appear before the learned trial court below in appropriate application. Next, considering the submission made by the consequences and the comparison of the record, the scene that the accused was shown as an abscond and the learned trial court below had issued only summons against the petition. Till that there is no order of issuance of warrant against him. However, considering the submission made by learned counsel for the petitioner, he is provided with some interim protection till 15 days from the date of order with a direction to appear before the learned trial court below, then appropriate application for bail, which may be considered in accordance with law. However, till 15 days from date of order, no coercive action shall be taken against reservation. The sentence. Okay, we are providing you 15 days interim protection.
Obliged. The next date fixed on 9th of March, my lord. Otherwise, in the last date, I have taken, my lord, the counsel for the appeal who is in the, before the trial court, he has taken time, my lord.
But
on
this
behalf
time we are giving only 15 days time
My lord.
within.
Obliged.
Yes, my lord. The main affair is at case number 14, my lord.
Is case number 14.
14, my lord. The main affair.
Yes.
সন্মানপূৰ্বক বিনীত নিবেদন এই যে যোৱা 28/12/2025 তাৰিখ দেওবাৰ নিশা 11 বজাত মোৰ ঘৰত পুৰুষজন নথকাৰ বাবে মই মোৰ ল'ৰা ছোৱালী কেইটালৈ শুই থকা অৱস্থাত নদুৱাৰ বনগাঁও অঞ্চলৰ 4 নং চাৰাগুৰি গাঁৱৰ শ্ৰী প্ৰজিত স্বৰ্গীয়াৰী ওৰফে বৰুৱা স্বৰ্গীয়াৰীয়ে আহি মোক ভয় ভাবুকিৰি ধৰ্ষণ কৰে। ইয়াৰ পাছতে মোৰ হাই হুলস্থুল কৰিবলৈ মানা কৰে। যদি হুলস্থুল কৰোঁ তেন্তে মোক জানে মাৰিম বুলি কয়। Actually, Your Honor, in this case, I'm the victim of circumstances as well as the situation, Your Honor, because on that day, the informant pulled over upon me to look over our defective scooty because as a
Defective story?
his defective scooty, Your Honor.
Defective scooty?
Yes, Your Honor. Though I am a tractor driver, but I know I some little more to repairing the defective motorcycle. So as a we know each other since long back in the locality. So that's why she called me to looking into her scooty. So that's why I have called for. So on that day also, her father was also called for at evening time and to have a dinner. So on the same day, the informant requested me to have a dinner. So I had dinner.
Very
and
nice.
Laterly, we left along with her father and me simultaneously with different vehicles. But some at the same time, the neighbors having seen us suspected us. And on the next day morning, the neighbors asked her to why she allowed me to enter her room in absence of her husband. So, accordingly, pressurized her to lodge the FIR, my lord. So, that's why, after 2 days, she met her sign on the ready-made FIR, my lord. But there is no any reason for delay lodging the FIR. So, it is the concocted story, my lord. But she did not lodge this FIR intention, but on pressurized, she lodged this FIR, my lord. And it is only on the suspicion, my lord. There is no medically evident proof, and there is only on the suspicion, my lord.
My lord, his submission may be correct, but at this stage, my lord, while allegation is of rape, any shortage may be fixed. I will get the thing.
My lord, further, actually, I am suffering as a wrist fracture, my lord, due to accident on 2 January 2026. So still, I'm not fully recovered. So, my lord, may kindly be protection, my lord. May kindly be till receiving the CD, my lord.
You are Mr. Das?
Yes, my lord. H.C. Das.
Heard Mr. H.C. Das, the learned counsel for the petition. Also heard Mr. P. Botak, the learned petitioner for the appeal. It's an application. So as in with Swens. It is submitted by Mr. Das that with some false and concocted story, the FIR has been lodged by the victim informant only on the as he was pressurized to file the scene. He submitted that on the fateful night, in the night of occurrence, he visited to her place as she invited him for a dinner. and thereafter, only when the village people suspected, she could not give the proper answer, and under pressure, she lost here. However, he is ready and willing to extend his cooperation in the further investigation of this case if he is provided with some interim protection. Next one, Mr. Bota wanted additional PP submitted in this regard that the allegation of rape has been brought against present petitioner, and accordingly he submitted that the CD may be to know the actual fact of the case. Next, considering the submission made by Swenson candidate is to exceed the privilege of interim clearance. Okay, you will be under interim protection.
Yes, my lord.
March or COVID.
27.
12th of March. Within 7 days, you appear before the IO.
My lord, to make kindly be sent the matter 11 March.
11 March.
Yes, my lord.
Okay.
Obliged, my lord.
You appear before the IO within 7 days from the date of.
Obliged.
May it please your lordship. My lord, your lordship may turn to page 21. There are a lot of allegations.
21.
21 is the affair. Vernacular is at page 26. Your lordship will find the date of affair is 9/1/26. Your lordship may go through because I will not speak it loudly because of my lord. And date of incident, they have said it is 27/12/2025. Next page, page 22.
Now, date of incident is 27.
7/12/2025. And 9/1/26,
FR was.
affair was lost. Not only that, but I will place some other facts also. There are a lot of allegations are there. I will not say in the open court. Your lordship, we just have a overlook over the FIR. Lot of bad things has been said and done. And the petitioner is an advocate clerk of Hailakandi Court. Well, this FIR was lost on 9/1. Prior to that, your lordship may now turn to page 11. Same incident, and a complaint case was lost on 31/12/2025, just after the incident. Complaint case, page 11.
Complaint was lodged on which date?
31/12/2025. And the cognizance notice was sent by the trial court, that is at page 20 on 3/1/26. Page 20, 3/1/26. Notice was sent. And in the complaint petition, one point, Mala, that I want to just one fact that I want to place that your before lordship is at page 13, last paragraph, in the fifth line, fourth line, Mala, page 13. Thereafter, while the condition of the sister-in-law of the complainant was getting worse, Sri Shahabuddin Majar Bhuiya, witness number of resident, took her to SK Roy Hospital. Your lordship may just remember this name, Shahabuddin Majar Bhuiya. That was in the complaint petition. About him, there was nothing in the FIR. Now, Mala, the date of incident was 27/12. Complaint was, incident is 27/12. 9 was 26 is the FIR. My lord, 31/12 was the complaint petition. T1 cognizance taken by, not the cognizance, notice was issued taken by the trial court. Now I take your lordship to, my lord, to page 28, where your lordship will find that on 25, my name is there, A. Hussain. I was traveling from Hailakandi prior to the incident to Gauhati. Booking ticket date is 25/12/25 and departure date was 25 December 25. A. Hussain number 1. I was traveling in train and I was not in Hailakandi. And the next page your lordship will find on 27/12 I purchased an online ticket. From 27/12, date of travel is 28/12 at left hand side page 29 top. when I was returning from Guwahati to Hailagandi. So that day I was not available there. And now, my lord, another document that I want to place before lordship, the vernacular at page 32, where, my lord, your lordship will find the wife of the witness number 1, who has made a complaint to the superintendent of police that he is the person who does all these things. The wife of the person I recalled in the complaint petition, that Major Bhuiya, against whom this FIR was lodged before the superintendent of police by that particular wife of that man, who has a habit of doing all this, and he has said that he has done all this. That was the FIR lodged by the wife of the name that I placed before lordship in the complaint petition. This FIR was lodged against that man, that he is the person who said that, in English, I will place it because he said,
No,
further,
complaint was lost. Complaint case is also lodged against you.
complaint was lodged in date of incident 27/12/25. The complainant lodged on 31/12/2025. 3/1/2026.
Notice was issued.
Notice was issued. Thereafter, the FIR was lodged. But in a complaint petition, particular the Sahabuddin Major Bhuiya, who was placed as a witness, nothing was mentioned in the FIR. And he is the person against whom the wife of that particular Major Bhuiya has lodged that he is the person who has done all this mischief and killed that girl. And I have shown my documents.
Oh, wife of said Sahabuddin.
Sahabuddin Major Bhuiya. That name.
Wife lost.
Wife lost.
His wife.
His wife lost this FIR. Against, that is at page 32. Is that he is the man who has done all this. And I have placed the documents, my lord, where I came to Guwahati for filing of a case. Even, my lord, the criminal petitions were there, where I have filed the cases on Guwahati. On 25th, I traveled from Hailakandi, and on the particular date of 27, I was never present in Hailakandi. And I returned on 28th, my lord. Page 32, your lordship will find that vernacular. It was received on 7/1/2026. And after all this information was received in the superintendent of police, then the FIR was lodged against me.
By whom? By whom?
By whom? That victim's mother.
So if everything is done by this Sahabuddin, why you're against you?
My lord, because I was working in the court, there was some maintenance problem with that particular mother, with the husband. So there was a problem. So they were putting the case against me, my lord. I was never present in that particular situation.
No, you were looking after the cases.
I was handling all those cases in that Hailakandi court. Being known to me, that is why they have placed my name.
But why?
Well, that is also because I was not available in that day in Hailakandi.
This can be procured. Tickets can be procured. It's
Well,
okay.
What I want to place it, my lord, I can appear and I will give all my, because even that day I was in Guwahati High Court.
But the girl died ultimately.
Yes, girl ultimately died. But I can place the documents that I was in Guwahati, that I was filing a criminal petition here in Guwahati. The numbers are also there, my lord. Because this affair which was received in page 32 was by Sahabuddin Major Bhuiya's wife has lost this case against this Sahabuddin Major Bhuiya, saying that he is the person who has done all this and he has a habit of doing all this in that area. Oh. Because the day when the girl expired by poisoning, I was not available. That is also true. Your lordship has said, my lord, the question came to me, I asked my friend why you were placed. Because they were known to each other during the court cases. Complaint case, notice issued, FIR lodged by Major Bhuiya's wife against Major Bhuiya, then the FIR lodged against me. If on 31st they could have filed a complaint petition, they could have filed the FIR on that day, my lord. Because, my lord, on next date is 9/2/26 for hearing of the accused in the complaint case.
Now see, Bhattakur,
My lord,
go by the page number 32.
yes,
There you see the name of the victim. She was a minor, and her name is Parveen Begum Barbuya
yes,
in page number 32. Whereas this particular in the FIR, the daughter is Samima Yasmin Laskar, that is 26 years. She is not a minor.
yes.
She's not a man.
The file. That means the victim, as you have submitted, is not the same one. Na?
Maybe, my lord, that
Then-
the ages are, because the
No,
victim.
ages no, these are different girls.
Yes, ma'am.
Your 32 is lost by, yes, their 32 is lost by the wife of Sahabuddin against
Barbing.
Sahabuddin for another girl.
Maybe.
She was
Because
minor.
the
And
victim
then
is 26.
she is not the girl.
Yes,
And this
and-
victim is valid other victim.
Everything is complicated. My Your Lordship, I would like to point
Everything is.
Moina Begum Loskar, my lord, name of the same, my lord, informant in both the cases.
Hmm.
But my lord, they are not same, man. Because one Moina Begum Loskar, the present affair who has lost, he is the wife of Kamrup of Borbhuya. And the complaint, my lord, is also Moina Begum Loskar, my lord, wife of Sebul Kalam Loskar. So two different persons, not the same.
No, the
Moina
issue
Begum
cannot be
Loskar.
different.
Name-
Issue is the same.
Name is same, and otherwise, my lord, here the allegation against the in the present affair, my lord, there are lots of serious allegations against the present petitioner, my lord.
Hmm.
And my lord, all these things will, my lord, come only, my lord, after perusal. Without
yes,
perusing CD, my lord, well,
Without praising CD, I'm not asking, my lord, that CD may not be called. Only thing that if I can go and give my submissions and everything before the court, my lord, I will
Let's
place
see
all,
what is the progress of the investigation, how far what is collected by the IO till date.
my lord, I will place all my
It's not a
submissions.
case of, anyhow, it's not a case of interim.
Well.
Heard Mr. P.K. Chaudhary, also heard Mr. P. Considering the submission made by both learned counsel for both sides and also considering the nature of allegation brought against so and so. I do not
Interim,
find it
Baba.
is to extend the privilege of interim arrest bill. Accordingly, the same the prayer for interim bail is rejected. It is CD called. Yes, when it can be called for CD
24-2.
Well,
24/2 will
well,
CD.
all right.
Lordship,
Yes.
it's an application in connection with section 303(2) and 317(2) of DNS, Your Lordship.
Secondly, we are
The
item number
petitioner,
7,
Your Lordship,
নামটো কোন নামটো খালি হৈ থাকিল যে the name has not been reflected, na? You have filed your wakalatnama.
yes, Your Lord.
Maybe inadvertently name is not been reflected. Anyway, what is your submission?
Your Lordship, my limited submission is that the petitioner is not named in the FIR, Your Lordship.
Not named in the FIR.
Yes,
Where
Your
is the
Lordship.
FIR?
Yeah. Page number 9, Your Lord. May I?
Hmm.
This is to inform that on so and about 9:20 p.m. one credible information was received from reliable source that a huge amount of stolen copper wire is stored at the scrapyard of Ziaur Rahman, located at Kanakpara under Azara PS. According to a general diary entry was made by Azara so and so by so and so
Then at about 9:30 p.m., I, along with PS staff, rushed to the scrapyard of Ziaur Rahman, and in the scrapyard, I found Ziaur Rahman, who is the owner of the scrapyard. Then I have found two independent persons who worked in the locality named so and so, and introduced them and briefed them about the purpose of search and asked them to be witness of the search procedure, and they agreed to do so. Then we searched the scrapyard of Zia as per procedure by video recording, each in presence of independent witnesses. So, Your Lordship, it is the recovery that alleged recovery that has been made it from one Ziaur Rahman, Your Lordship, and the one of the co-accused has took my name, Your Lord. So I have a fear of apprehension. So that is my humble submission. I was not even named in the FIR, Your Lordship.
The recovery was from
The Your Lordship,
the Jiabur.
yes.
Your Lordship may kindly come to page 15, my lord. Second paragraph. One item number 8 is also, my lord, or one petitioner, my lord, Baghdad Hussain, my lord. He is petitioner number, he is in item number 8, my lord,
Eight.
petitioner. And Nazimuddin Ali, the present petitioner, and Khalil Ali, along with other co-accused persons, and the bench case diary reveals that above named petitioner, along with other co-accused persons, committed theft of the aforesaid article. So he, along with the other two accused persons, my lord, committed the theft.
It's a government property.
Yes, my lord. From the, my lord, construction site of the airport, my lord, 75 kgs of copper wire, 2 numbers of UPS, and 3 numbers of sockets used in,
So
my
after
lord,
committing theft, those were sold to that in said
yes,
scrap
Ziaur Rahman.
Ziaur Rahman.
Those were recovered from the scrap shop of Ziaur Rahman. Item number 8 is, my lord, that is Baghdad Hussain. One.
So this was the anticipated bail prayer for one Nazimuddin. Your name is Nazimuddin?
Nazimuddin,
Yes.
Achha. So while disposing the bail application, the name of two others are also there. That is
Baghdad Hussain and Khalil.
Baghdad Hussain and
Khalil Ali.
that Khalil also is there. No? Your good name?
S. Hawk.
S. Hawk. Who is Dr. D.J. Decca? Name of Dr. D.J. Decca is reflected in for item number 8.
No, he's my advocate colleague, Your Lordship.
Is your colleague.
Yes.
Now your name is M. Hawk.
S. Hawk.
S.
Yes.
See, the name is not there in your FIR because it was a search was conducted in the scrapyard.
Yes, Lord.
And during the investigation only it has come that you are the person who committed the actual theft, and then it was sold to that scrapyard of someone, Jiapur. So let this CD be called for. We'll see is the progress of the case, whether is anything is to be recovered and what is the other.
Your Lordship, at least interim protection may be granted. We are
He is a
willing to
thief. How
cooperate
can we
with the
protect him?
investigation
You
authority.
go to
Any
do
sort that may
another
be fixed,
another
my
work
lord.
now. He's a thief, na?
Sure.
Your petitioner, both the petitioners are thieves. So if they
Yes.
just simply
In case of granting him, they will again, my lord.
he will again
Same type of.
do these things because he is a habitual offender. I heard Mr. S. Hawk Corridor or heard Mr. So and so, considering the nature of the offense. Find it necessary to call for the case diary, but with an order again 7 and 8. Case diary before passing any order. Simply look. Yes, I guess 24.
Yes.
24 to we are listing both the matters.
Hello.
Seven.
May I please, my lord?
Yes, Mr.
My lord, this application is filed seeking, my lord, transit pre-arrest bail, my lord. My lord, this FIR is lodged at my lord, Cybercrime Police Station, Gurugram, in the state of Haryana, my lord.
Lord, in these days, my lord, these cyber offences are, my lord, continuously going in all over India, my lord. Some of the places in Assam also now one of the hotspot, my lord. So my prayer before lordship, this type of, my lord, transit, they may approach before that, my lord, jurisdictional court, my lord, without getting any, my lord, transit anticipatory bail, my lord. Otherwise, in case of, my lord, these are not cases, big cases for granting anticipatory bail. These are serious cyber offences, my lord, continuously going on everywhere, my
My
lord.
lord,
Assam, my lord.
my lord, the FIR start at page 13, my lord. If lordship may come to page 14, my lord.
They are involved in committing offense outside the state, and thereafter, my lord, after getting transit anticipatory bail, my lord, they will again, my lord, now, my lord, regarding those, my lord, my lord, some of the cybercrime offences, my lord, nationwide in many of the states, my lord, this type of, my lord, ultimately in Assam, my lord, Assam is a hotspot now in
Now
Gauhati,
hotspot,
my
yes,
lord,
yes.
in some of the districts.
My lord, if lordship may come to page 14, my lord.
Mm.
My lord, column number 2, my lord, first information contents, my lord.
Mm.
May I read, my lord? To SHO Cybercrime, Sector 43, Gurugram. Dear sir, I have been fraudulently cheated through following mobile stock broking applications of stocks. Number 2, Bajaj
You're
Fine
14 or 15 years? Which one? Please?
14, my lord. 14, my lord, bottom part, my lord.
Oh, acha.
My lord, dear sir, lordship,
Hmm.
I have been fraudulently cheated through following mobile stock broking applications. Upstocks, number 2, my lord, Bajaj Financial Securities Limited. Fraud details of Upstocks. Mr. Iswaram had made a mobile call around April 18, 2025 to register myself on Upstocks through mobile number so-and-so. As Divyangna has been coordinating to make investments through WhatsApp by mobile number so-and-so and so-and-so. Upstocks also has a WhatsApp group called Trading Strategy Research Study Group, which has over 100 members. The group is led by Mr. Kapil Jayalakshmi Bhaid, mobile number so-and-so and so-and-so. I also suspected that Mr. Vas Sambare to be mole who acts as investor. Her mobile number is so-and-so. She reached out to me, sharing wonderful fund withdrawal processes. The Upstocks application is active even as of now. The Upstocks mobile application shows an amount of rupees 2 crore 24 lakhs 70,890. When I wanted to withdraw the money from Upstocks account, they demanded rupees 48 lakhs as commission prior any withdrawal. This is how I realized that it is a fake or fraudulent account. I deposited the funds as follows. Date, beneficiary details, UTR amount. Then, my lord, he has deposited in this bank accounts, my lord. There are different bank accounts, my lord, related to different, my lord, estates. Only, my lord, one transaction is there, my lord. That is 2/5/2025 of Sobham Supply Services, ICICI Bank, Paltan Bazaar. That account number is also there. And my lord, in this account, he has transferred 1,50,000. And again, my lord, similar with the allegations are with that, my lord, Bajaj Financial Securities, my lord. What happened? What I gathered, my lord, these are all online applications are there, my lord. They have given something that they have made a group and they give some services or advices, and after that, these all things, and he has voluntarily deposited all these amounts in the different accounts which he has mentioned in the FIR, my lord. My lord, I have annexed my bank account. That is at my lord page. It starts from page 17. Well, no account, no money is transferred in the bank account of the petitioner, my lord. Even in the FIR, my lord, all the accounts mentioned and even the names and whatever is there, my lord, the petitioner name is not mentioned there, my lord. Only, my lord, on 15/2/2025, my lord, 15/12, my lord, 15/12/2025, I have stated in my lord my paragraph 2 and 3, my lord. If lordship may take up my statement. The police from the my lord cybercrime police station Gurugram visited my residence in my absence along with the local police and they searched me. When my wife says that my lord he is not there, my lord, they went out only by saying that one case is there in the state of Haryana. On the same day, I have received a phone call, my lord. I have given the phone number also in paragraph 3, my lord. And he has informed me that, my lord, there are altogether, my lord, 4 cases are registered against this petitioner, my lord. But I have, lordship may go through, my lord, this bank account, no money is transferred. And my lord, this is not a case of what my friend is suggesting, that fraud and all this. Bank application, he voluntarily went into the group.
No, your petitioner, what he do? Your petitioner.
He is a petty businessman. He resides in my lord, Kalapahar, Gauhati. He works as a middleman in selling the, my lord, old cars, man. I have given the statement in paragraph.
So in that group, he was not there in that group.
No, he's not at all involved. Even he is not named. His bank account is also not mentioned, my lord.
So you're mentioning one account, bank
Yes,
account of one.
only one account of Assam, my lord. That is at page 15, my lord. Page 15, my lord. The date is 2/5/2025. In the first paragraph, my lord.
2/5.
2025.
Shubham Supply Service.
In the first paragraph, my lord, from the bottom 7th line, my lord. From the in the first paragraph, page 15, from the bottom 7th line.
Shubham.
2/5/2025, Shubham Supply Services, ICICI Bank, Paltan Bazaar. Account number is given, IFC code is given, and then, my lord, amount is.
That account is not operated by you?
No, my lord, I have annexed my bank account, my lord. That is at page 17.
What do you want to say? How notice is issued against you, or how 4 numbers of cases have been registered against you?
My lord, I have downloaded all the FIRs, my lord. All the similar things are there, in the FIRs, my lord. Nowhere this petitioner name is mentioned, my lord. And why the police is searching, that I fail to understand, my lord. But the only thing is then that I have to go to the state of Haryana to file any application. I'm only seeking, my lord, for a period of 3 weeks, my lord, the protection so that I can file the, my lord, application before the jurisdictional court. I'm not involved, and my lord, I do not have any connection with all this, my lord. Because if any money is transferred, then my bank account number is mentioned there, my lord, or the money is transferred into the bank account.
You have annexed your notice here?
No notice, nothing is there, my lord. I have given my statement in paragraph 2 and 3, my lord. First, they have visited my residence, paragraph 2, my lord, and 3. First,
so the first information, how you got your first information report?
The person has called me over telephone. He has introduced by saying that he is calling from, my lord, cyber crime police station Gurugram, and his name is Surinder. Then he has demanded some money, and then he has informed me that these are the cases registered against you. I have already downloaded the FIRs, my lord. All similar types of allegations are there. Here I am only for the one. I have filed another 3 that are not listed, my lord, till now. Here only, it is only for 181, my lord. If lordship want to go through the other FIR, then lordship may take up some other day, let all the applications come to me. Because I do not have any connection
Really,
with.
my lord, there is no apprehension on his part. Suppose if somebody makes him a call demanding money that against you, all these cases are registered. So my lord, he should have immediately approached before the police station, my lord. Lodge a, my lord, FIR against that person, my lord. That this is the person who demanded me money by, my lord, stating numbers of some cases wherein I am involved. So it is your duty. You will have to immediately lodge FIR against that person. That I have received as a phone call from an unknown source, and he demanded me money. So why you have not lodged any FIR? And where is your, my lord, apprehension, man? Then only because somebody makes you a phone call that you are involved in this case, and for that he has, my lord, approached before this honorable court for getting anticipatory bail.
But these FIRs are against him also, I think.
My lord, against him, my lord, he only, my lord, he received that from that phone
No,
call.
in this FIR, your name is here, no?
No,
nothing
name
is
is
not
there.
here.
Name is
Then,
not
then
there.
what is
And
your
in
FIR
other
section?
cases, my lord,
My
he
lord,
has not.
My lord, paragraph, if lordship may come to paragraph 2, my lord, of my petition, my lord.
That may be a factful, my lord.
Paragraph 2 and 3.
No, but he's saying that these are the cases against you. So he have collected somehow through online you collected those the copies of the FIR. I can understand, but these FIRs does not reveal your name.
No.
You are not the person. So why you are apprehending?
My lord, police has visited my house, my lord, along with the local policeman. And now they are calling me from the cybercrime police station regularly, asking me to come to that police station. So that's why, my lord, I am apprehending.
And he also my lord, made allegation that they demanded my lord, money. So for demanding of money, it is your duty to immediately lodge a FIR against that my lord, police person who has demanded money.
Because, my lord, I am apprehending, that's why I have approached this honorable court, my lord. Only for a limited time, lordship, not 3 weeks. Let me approach the jurisdictional court, my lord. If I am found anything is there, my lord, then that court will certainly, my lord,
And
not grant me the.
if he apprehends only in one case, in other 3 cases also, he will have to again.
My lord, I have already filed the applications that are not listed. If that's why I submitted. If lordship want to go through the other cases, then let it may come on Friday, my lord. I will also mention all these 3 cases on Friday. Let all the cases come. Since my friend is saying, my lord, let this case alone. I come on Friday. I will mention other 3 cases also on Friday.
He is involved in all these cases, but it seems that my lord, he is a veteran, my lord, cyber officer. Otherwise, if he is in fact involved in all these cases.
Mr. A.K. Gupta, the learned counsel for the petitioner, and also heard Mr. P. Botaku, the learned additional appearing on behalf of this is an application seeking anticipatory bail. Go ahead. Seeking transit pre-arrest bail to the present petitioner in connection with cyber crime police station case number 181 of 2025, Gurugram, registered under section 318 of subsection 4 of BNS. It is submitted by Mr. Gupta, the learned counsel, that if he is no way involved in the alleged offense, and on 15/12/2025, some of the officials of Cybercrime Police Station Gurugram, accompanied by some local police personnel, visited to his residence with an intent to arrest him in connection with cyber crime police station Gurugram PS case number 181 of 2025. And as he was absent, indeed, and during that time, it was informed to his wife that that he is the station on being it's not restaurant. I'm informed to know his wife. It was asked to his wife to surrender the present petitioner in the said case, and also stated that 4 numbers of cases has already been registered against him. Coming to know about the same, he somehow obtained these copies of the FIR housed for the cyber PS Gurugram as stated above. After inquiring the matter, it has come that there are some transactions numbers of the bank transactions done by the informant, and out of which only one transaction has been made on 2/5/2025 of Soham Supply Services, SHOVAM Soham Supply Services, ICICI Bank, Paltan Bajar, with an account number. But the present petitioner does not have the said account number and he had also annexed his account number, and from the account number it is also seen there was no such transaction as stated in the FIR. However, as the police personnel from Gurugram as well as the local police station has searching for the present petitioner, he is an apprehension of being arrested, apprehension of arrest in connection with the said case, and hence the present petition has been filed seeking the transit anticipatory bail so that he can appear before the police station of Gurgaon so and so so and so, and can record his statement. Next part. Mr. Botaku, the learned additional PP submitted in this regard that there are numbers of cyber offences are going on in all over the state, and Assam has become the hotspot of the state of the such kind of cyber crime. He further submitted that as per the uh, the the uh, the petitioner, uh, if any demand of money was made by the police officer, he could have approached the police with an FIR against the said officers who demanded money. Further, he submitted if the petitioner is not at all involved and if there is no transaction in his bank account, there cannot be any apprehension of arrest in connection with the said case. Accordingly, he raised objection and submitted that this may not be a fit case to extend the privilege of uh, transit anticipatory bail at this stage. বাকিখিনি এটা মোৰ ফৰ্মেট আছে তাৰপৰা লিখি ওকে আৰু পাঁচ
Published.
হেৰি আছিলে
Lordship dispose of date maybe kindly be method till date. Yes.
Published.
আগতে চাই ল'ব লাগে আছে কিমান তাৰিখৰ এটা এটা may please Lordship. Lordship, the petitioner were forwarded on Lordship 19/11/2025, and as on today, Lordship 84 days behind the bar. 19/11/2025. As on today, Lordship 84 till today, Lordship 84 days. Lordship, allegation under section 178 and 180 fake currency.
Total 36,45,000 of my fake currency recovered from the present. Yes. Petitioner along with two others.
3 persons were arrested, Lordship. Lordship, as on today, Lordship, I am pressing on the ground of length of detention, Lordship. Since Lordship, they are already behind the bar substantial period of detention, Lordship. So their further investigation might have progressed, Lordship, and that further detention may not be required for the purpose of investigation, Lordship. Yes, Lordship, 90 days.
Dispur police station, my lord. Otherwise, my lords, huge quantity of fake currency recovered from the present petitioner. Well, so
I mean,
length of detention
now
also, my lord, I have objection because these are not the offences, my lord, online. So, my lord, my prayer before Lordship, my lord, although today 83 days completed, my lord, they are not entitled for bail. Although, my lord, 83 days, I may be allowed to return back the CD. I will have to Lordship, we are ready to cooperate with further investigation.
For
Lordship,
huge-
Lordship may give any direction.
Serious economic offences, my lord, huge quantity of my lord trick kinds recovered from the present.
How many notice? 36 lakhs.
Total, my lord,
Lordship, 36 lakhs 45,000. Lordship.
total 7290 pieces of suspected my lord, FICN and total,
500 rupees.
total value 36 lakh 45,000 from the position of all these serious economic offences.
Lordship, we are ready to cooperate with the
What
investigation.
say now? Admittedly, today is
Otherwise,
80 or
your lordship
84.
may fix, my lord, today is my lord 83 days. In the meantime, my lord, there may be a lot on 18th of
No, 18 will pass.
on 17th to my lord. I may be allowed to return the CD. Do you think in the meantime?
Lordship, I am praying, Lordship, on the length of detention, Lordship. Will
He is suggesting that the
Lordship,
nature of case on that only is
Lordship.
because the fact
Lordship,
currency-
Because
In the-
huge quantity of
in the
fake kinds.
forwarding also, Lordship, there is no previous offense is mentioned so that they can claim that Lordship that they are a habitual offender, Lordship. So on that ground also, Lordship, will appear before the IO, Lordship. Lordship may give any direction, Lordship. Will cooperate with Lordship. The
Otherwise,
investigation.
just tell me, it's okay because only 4-5 days or 6 days left.
Yes.
Maybe at best 6-7 days. Now, what is the progress of the case as per the?
My lord,
the
investigation almost completed, my lord.
but is there any note that it is going to
Yes,
submit?
only because of my lord, FSL report not yet received, my lord. That is that for that reason, my lord, search sheet not yet filed.
Lordship, since Lordship only pending for FSL, Lordship.
So, can it be there any expectation for receiving this FSL within 6, 7, or 5, 6 days?
Yes, my lord. Possibility.
Otherwise, again,
possibility is there, my lord.
possibility is there.
Yes.
Lordship, since it is pending only for FSL.
If my lord on that day on your lordship may kindly fix it on 17/2, my lord. If on that day my lord search it not, well then your lordship he is entitled for default bail on that day.
Otherwise,
And
Lordship,
you are
there is
going to return this.
Yes, my lord. I will return the CD. Otherwise, my lord.
In that case, we have to write
Because-
the entire order on merit also. That's what I'm saying. Or you can do one thing otherwise. We may fix it in 15, I mean, 16 or 17, whatever.
17 to your lordship.
72, just a second.
In the
72,
meantime-
and in that case, let the an information be,
Yes.
you can collect the information
Yes.
as to whether the FSL has already been received by.
Yes.
That can be done.
I will be allowed
Otherwise-
to return back the CD.
Lordship,
And I
otherwise,
will get the instruction, my lord. If-
there is no chance of hampering the investigation also since it is only pending for FSL. Lordship.
Get into administration.
K. Thakur on behalf of D. Medhi, madam.
Appearing for DMED.
Yes, Lordship.
DMED. Mr. K. Thakur, the learned counsel, appearing for Mr. DMED for the petition of report and considering the submission made by Mr. Portable, let the CDB return, asking the IO to furnish updated one on 17 2026. Without passing any order on matter. Let the matter be according to list 7. We are not passing any order on matter. 17.2 we are listing it. Let him try once.
Then CD will be returned or retained.
CD will be returned, otherwise we may not be in a position, or if suppose it doesn't come, then we'll take instructions on that.
God bless you.
Today's fixed for matter CD, madam. Just petition is-
Not received, my lord.
I have the instruction that, madam. Madam, that's it submitted.
It is submitted.
Madam, may I pay, madam,
Number
that's
two.
number.
After
Sir, there's Sasit maybe, madam, call for madam. Otherwise, I have to wait, madam, under one.
Instruction. You just give me your instruction.
After some time, my lord, I will try to get the instruction.
Take instruction.
Diploma.
Here, my lord, the same person, my lord, item number 12 and 13, my lord. 12 is shown arrest, my lord, and 13, my lord, the main case, my lord. In the main case, my lord, diary is not received, my lord. Can we have it on Friday, my lord?
I cannot say again, it has to be.
Then Monday, my
Let
lord.
it be maybe on Monday or Tuesday.
Monday.
Yes,
Monday, which date? It is?
16.
Let it be on 16.
Yes.
Because the main case diary will be required.
Okay. City not received, issue reminder. Estimate. Okay, well, it's
I'm obliged.
okay. 14, what is the position? Not received.
No.
Is the for case diary from Gauhati GRPS.
Yes.
None appears on call for the petition. We did not receive. Issue reminder. Estimate accordingly on. Let it be on T2 part khula ase aro. Please.
Maybe.
Yes.
My lord, Her Lordship will find, my lord, the affair at case 9, my lord.
First
Just
submitted, man.
That's it, sir.
Now, my lord, petitioner,
He is
Your
in
Lordship,
custody since when?
is a law student, my lord, and he have law class, my lord. Allegation is, my lord, his father suspected to be involved in the present case. That is why he and his mother has been, my lord, picked up and they are in custody. Father has been suspected to be involved.
So under
Otherwise, this young boy has
which
no,
section it has been registered?
my lord, section, my lord,
Fake currency, my lord.
no, fake
Oh,
currency,
it's
not
fake
fake
currency.
currency.
Fake
Section, my lord, 305A,
Oh, sorry, man.
theft of article,
or theft of.
Item number of not 15, man.
15.
Fake currency.
Fake currency, it is frauding report.
Is of fake currency or
Page 17. It is not related to fake currency. Some gold ornament has been, my lord, stolen, and it is alleged that those stolen articles, my lord, has been hidden in my residence. That is, my lord, Chandan, the father of the petitioner. That is the allegation, my lord.
you are Ramchandra?
I am Ramchandra. I am a student of any of law college.
Wait.
My lord, we are having the, my lord, ID card.
No, whatever. Now charge sheet has been filed. We are not going to pass any order at this stage.
And as on today, my lord, 32 days in custody.
179, 180.
What is the charge sheet number? It is a case or it's not the case?
Yes.
No, you are
No, this is the case,
bit
man.
confusion.
This
Huh?
is Balgobin Jaiswal.
No.
No. This is Ramchandra Das.
Ramchandra.
Wrong file, my lord. This is also mentioned as item number 15, man.
Can it be after some time, my lord? In the meantime,
Yes,
let
after
them.
some time, man.
Okay, just
Yes,
wait.
obliged.
Please, Your Lordship. 483 application, my lord. This is a shown arrest case, my lord. In this case, Lordship, I have taken the plea regarding the non-mentioning the earlier case in the forwarding, my lord. We are not in the name if FIR was accused, my lord. FIR will be at page 12, and my lord forwarding Lordship will find.
In this case, is there not
But my lord, before going to the case diary, kindly see that Lordship, this related to cow lifting case, my lord. But in this case, earlier they were arrested in connection with Patsala PS case number 3. I have annexed those forwarding report, my lord. It is Lordship will find those forwarding.
Your case is Pachala or Patasar Kusi?
Now I'm
Patasar Kusi.
I'm moving Patasar Kusi, my lord. Earlier, I was arrested, Lordship, in connection with Patsala PS case number 3. That forwarding, Lordship will find at page number 18. in page number 18, serially lordship, it is mentioned, but in that those forwardings, my lord, this earlier case, this case was not mentioned, my lord. That was initial case, my lord.
Tell us, your earlier case was Pachala.
Patsala, I was arrested. And this present case, I have been shown arrested, my lord. Patasarkusi. My lord, in Patsala case, I have annexed the forwarding report, page 18, for one accused and thereafter other accused, lordship. Page number?
Just tell us, this Patasar, your earlier Pachala, you were forwarded on which date?
For accused Akifur Rahman, lordship, I was forwarded on lordship 14/1/26.
14/1/26.
Lordship. Then thereafter, lordship will find at page number 23. That is lordship on 5/1/2001, 5/1/2026. Then thereafter, for other accused, lordship will find at page number 25. The date of arrest is 7/1/2026.
Your present FIR is lodged on?
My present FIR was lodged on earlier, lordship. Lordship will find at page number. Translated copy, lordship will find at 8/1/2026.
Is Botakul they are taking that plea that the cases which were pending against him were not shown in the forwarding?
Yes.
Otherwise, what do you want? You have not received the case.
Yes, IO has paid for some time for my lord.
Now, time today, from it will bench will only up to 1.
Yes.
And from 2, there are matters we are not going to hear.
Not today, but IO has, why he could not send a CD, my lord. He paid some time for producing the case there. Even today,
In earlier case, it is the shown arrest. In the earlier case, you were already on bail.
Yes, my lord. Yesterday that was
You were on bail.
But right now we did not get the copy, my lord. It was before the court number 24.
In this case, shown arrested on 19.
Shown arrest on
19/1/20.
But my lord, thing is that in the forwarding, our High Court and in Farooq Abdullah case, lordship, it is mentioned that if person arrested, then in the lordship is aware about these things. For in the forwarding, they have to mention this all the case which are pending against our accused person.
And in the present case, you are forwarded on 19/1.
One is petitioner number 3 is on 19/1/21. No. All are 21. 21/1. 21/1. So this.
What to do? Because she is claiming on, taking that plea of non mentioning about the dependency of the other cases at the time of forwarding. Because I'm just repeating, the FIR of this present case was lodged on which date?
8/1. No?
8.
No, sorry.
And you are forwarding in Pachala, in Pachala?
Forwarding in Pachala on 19/1. Oh, sorry. One is 5/1, another is 7/1, and petition number 3 is 13/1, 14/1.
That in that case, that principle may not be applicable, because if your FIR is not suppose registered on the day when you are forwarded, that they may not be a case for that plea.
But lordship, regarding this other two person, lordship, other person at petition number 3 and 4, to that regard, this is applicable, my lord.
May be applicable, but
my lord,
for I don't know who is forwarded as the date when the case not even registered. In that case, that may not be applicable. Anyway, you have not received the case diary.
Case diary, my lord, any sort from
Patasar Kusi, my lord. Can be tomorrow, day after tomorrow, lordship, from Patasar.
Tomorrow list is already over.
Day after tomorrow, lordship.
And be listed. Day after tomorrow.
On Monday or Tuesday,
my lord, because we have taken already in other case, they got bail.
Day after tomorrow, can you?
Yes, I will
let's try, my lord.
We'll try.
On 13, my lord, Friday would be appropriate.
13, I'm not here. Can it be on Thursday, my lord? Because 13 I have outstation case, lordship.
Thursday, if my lord again schedule will not come, my lord again.
Let's see, my lord. Let's try my luck, lordship, on that day.
We don't want to hear the similar submission. That's why if 13,
On 16th, my lord, Monday, it would be on Monday, I can produce the schedule.
My lord, it will same team, lordship, if I got the bail in other main case, my lord. In this
I can
case,
understand.
that is why,
I can
lordship.
understand.
Yes, that Thursday, my lord, yes.
13. Oh, what?
Thursday, 12.
Thursday. Thursday means 12.
Obliged to lordship.
CD not received. Issue remand. Bill. Timing to asset.
14. So my item has been mismatched.
Item number
Actually,
14.
item is for 14.
15.
14 none appeared, my lord. 15, my lord. Item number 15. 15, my lord. Ramchandra Das, my lord.
Lord, as on date, my lord,
Ramchandra Das, you are appearing.
Yes,
Yes.
CD not received, my lord.
32 days
CD not received.
in custody, my lord.
So 14 is different thing.
14 is different, my lord.
14 is non-appear, no? 14. 14 non-appear. 14 we are listing it on 20.
এখন আপনার final.
So 15 you have not received the case there.
Not, I have not received the case.
Now,
He is saying that he is in 32 days. What do you
Yes.
want to submit, Mr. Potakot? You want the CD or even without?
now is he student of my lord, any of law college?
What is the nature of case?
Yes. My lord, page 9, lordship will find the affair. Now, my father has been suspected to be involved in a my lord, theft item which has been alleged to have been hidden in my house. Accordingly, my father is my lord, fled away, and myself and my mother has been picked up. Page 9 is the affair.
It is serious, man, by breaking the.
So where it is stated that in absence of father, you are caught.
Yes, myself and my mother has been picked up.
No, where it is stated?
My lord,
Where from you are saying?
yes. Now it is from the my lord, according report, lordship will find page 17.
17.
Yes, page 17 is started, my lord.
Hmm.
Property part, my lord. Page 19.
Hmm.
Paragraph 5, my lord.
Hmm.
Page 90 paragraph. During the course of investigation, credible disclosure made by co-accused person revealed that after the commission of the offense, stolen articles were brought to and temporarily concealed at the residence of the Chandan. Lordship, kindly see. Chandan. Chandan is the my lord, father of the my lord, petitioner, where his wife Mamoni Das and son Ramchandra Das were present. It has been revealed that the Mamoni Das and Ramchandra Das were aware of the presence of the co-accused Amirul Mujibur at their residence immediately after the commission of the offense. Despite having knowledge of the commission of the cognizable offense and presence of the stolen property, they failed to inform the police or lawful authority. During the interrogation, both Mamoni Das and Ramchandra Das deliberately withheld the information regarding the events of the said night, despite being in a position to provide crucial facts necessary for the investigation. Next, Miller. The accused driver used to rented vehicles for facilitating the commission of the offense, and the said vehicles have been seized from his possession as materials evidence. During the interrogation, the accused driver disclosed the names, identify, and roles of the other co-accused person, namely Mojibur, Amirul, and Chandan, thereby revealing his active participation in a criminal conspiracy. Now it is realized that Mullah, we know the incident, but we did not inform the police. That is the allegation. And I am a student of law college, Mullah, Ania. we are having the identity card issued from the college. Now, considering the detention period, since nothing has recovered from us, if it is concealed in my
recovery is from your house?
no, nothing.
Look.
Nothing has been recovered. Had it been concealed in my house, definitely
Your identity card is reveals the name of Pranjal.
Pranjal, yes.
So where from you're saying that you are
Pranjal
Pranjal?
is Ramchandra Das and Pranjal Das is the same person,
Where from you're saying? Is there any document?
That is
You're repeatedly saying that he is a student of law college.
yes.
It is the issued in the name of Pranjal only.
Yes, Pranjal.
There's no name as Ramchandra.
Yes, Ramchandra. We have stated he has
No, you have stated there is no document. That's what I'm
yes,
saying.
that is there.
Where from you're saying?
Earlier, his name was Pranjal Das. Subsequently, it has been changed to Ramchandra Das.
Where from you're saying Ramchandra Pranjal? It is your submission, Ramchandra and Pranjal.
Now, in any case, considering that the detention period is 32 days and nothing has been recovered from me, my lord. Detention period may be considered.
So we're submitting Ramchandra and alias Pranjal when there is no document at all. This is your submission, Ramchandra alias Pranjal. There is no document that Ramchandra alias Pranjal.
That's true, but except
Yes,
the identity card.
No, otherwise offense is serious. My lord, these all accused persons, my lord, thereafter Sondon, residents of accused Sondon, my lord, the put this only CD any sort that may be fixed, my lord, I will get the considering the nature of Mamuni dust may be considered, but Mamuni dust.
Let us see your identity card.
Yeah.
Sano?
Son of my lord Sun Kumar Das, alias Sondon.
Everywhere you are saying alias. This is no alias, alias, nothing is there.
And whether
Chandan is not yet arrested.
Ramchandra Das, alias Pranjal Das.
Ramchandra. Your father, his father is not yet arrested.
Not yet arrested.
His name is?
Chandan. My lord.
Chandan is Sun Kumar.
Good name is my lord Sun Kumar Das.
Without my lord, again it will
Chandan.
say, my lord, again as Sun Kumar Das and Chandan is not the same person. My lord, again this.
Where from you are saying Chandan Sun Kumar is same person?
Lord, earlier name was my lord.
No document at all. Sun Kumar Chandan.
Yes, except this I have no document, my lord, because there is none in the house, my lord. Mother and boys, my lord, picked up.
No, you can give, na?
Yes.
You're very tactfully you name give the name of the petitioner, the Ramchandra alias Pranjal, son of Sun Kumar alias Chandan, but there is no document.
Now I have been not instructed. Earlier his name was Ramchandra. Subsequently it has been changed to Pranjal Das by way of affidavit. That is my instruction, my lord. Anyway, let them, my lord, if they creates doubts, my lord, let them verify. If I am not the same person, then it will be another offense, my lord, from my side.
Yes.
And he specifically mentioned that co-accused Amirul and Mojibur, my lord, immediately after commission of the offense, they were well aware about their presence in their residence. And maybe at that point of time, my lord, Sandan was not there. My lord. Whether who is Sandan, my lord, that is also, my lord, it is difficult to say at this point of time.
Chandan is the father of the petitioner, as revealed from the my lord, frauding report itself, page 19.
Page 19.
Yes.
Yes, where from? Chandan.
Yes, Chandan. Paragraph 5. Just I have, my lord, read out, my lord.
And main accused person is Mojibur, Amirul, and Sandan.
But is there any from where from you are saying that Chandan is the father of this Mamoni, husband and father of Mamoni and this Ramchandra?
It is revealed from the
Ground number 5, my lord.
FIR, my lord, ground number 5.
Ground time name of one Chandan is there.
Yes, Chandan is there.
But,
From there,
his
my lord.
wife Mamoni.
And my lord, who is that Chandan, my lord?
So, but as per forwarding, Mamoni and Ramchandra are the son of this, they say Chandan.
Yes,
Yes.
son and wife of the Chandan.
But here again it is saying that Sunkumar Das.
Hmm.
Anyway, here it is written. Yes. In para 5.
Yes,
So as per you, they were not aware of.
yes. And my information, my lord, nothing has been recovered from my possession as well as from my house.
So, but every this ornaments etc. were in your house only.
That is the allegation, my lord.
Till then there is no recovery.
No recovery
No,
from my house.
No recovery from your house.
No recovery.
How, Mr. Robot? Because as per the FIR or as per the forwarding report also,
Yes.
everything was there in their house. But if there is no recovery, how can you say? Okay.
did you
Heard Mr.
reveal the exit?
Heard Mr. M. Mondal, the Danet Council for the petitioner. Heard Mr. P. Waterfall, the Danet additional PP appearing on the post. This is an application section so and so in connection with so and so. C did not receive. No intimation is received from the next right is submitted by Mr. Mondal, the Danet petitioner, that the present petitioner along with his mother were picked up from their house as they could not rest their father Chandan, who is stated to be the prime accused from at the time of their search. But the present petitioner, who is the son of Chandan alias Sunkumar, is not aware about any offense committed by his father, as well as in the FIR as well as in the court. Further, it is submitted by Mr. Mondal that the following report itself, it is seen that only allegation against this present petitioner is that they did not provided the necessary information of his father Chandan alias Sonkumar at the time of search, and for which reason they and as they were aware about the incident, the son of said Chandan was arrested in the present case. Mr. Mondal further submitted that there is no direct allegation of theft against the present petitioner, and it is the only allegation against him that he did not disclose the information in regards to his father and was aware about the facts of and was also aware about the commission of offense, but did not inform the police accordingly. But till date there is no recovery from the house of the present informant, a present petitioner, though it is alleged that all the theft articles were kept concealed in their house. Mr. Mondal further submitted that till today, the accused petitioner is in custody since 32 days, and hence considering the length of detention, he may be released on. I got sufficient opportunity to interrogate him, keeping him in custody. However, he will extend his cooperation in further investigation. He is a student of law, and considering this aspect, he may be released on bail. Next, Mr. Botaku, the learned additional PP, raised objection and submitted that considering the nature of allegation, the present petitioner may not be allowed to go on bail without preserving his diary, wherein the allegation of theft of valuable goods, that is the gold ornaments, is brought in Liapat. It is submitted that the result of the case diary is necessary before passing any order. Next, hearing the submission made by the case record and especially the boarding report, where it is specifically stated that the reason for arrest is where it is specifically stated about the reasons for arrest, and that the accused was arrested only because he did not disclose the information about the commission of the offense, as well as did not disclose the information regarding the main accused, Chandan Das. Considering this aspect of the case vis-a-vis the length of detention already undergone by the accused petitioner, I find that further custodial interrogation may not be necessary for the interest of the investigation. In view of this, I find it a fit case. Where from it is has to be?
My lord, CGM Kamrup Metro.
To the satisfaction, CGM.
Deep law place. I got to go.
11. Oh yes, what about the 11?
Information matter, charge sheet submitted.
Oh, charge is submitted. Na? So you may approach before the learned trial court below.
Well, that may be committed to the session judgment. It will take another one month.
One?
1 month, my lord. The Lord, my lord, Sasura submitted before the SGM. That committed to the matter, talking to my lord.
Till now, how many days you were in custody?
Now, my lord, almost 1 month, my lord. 15, my lord, I was arrested, 15 months.
Almost 1 month. No, as case has already been charged, we do not want to
But it
pass any order here.
Otherwise, it will take another 1 month, my lord. You will have to, before the my lord,
You just try it, because the case is, under which section case is charged?
87, 87, my lord. It's a law of affairs, my lord.
Huh?
It's a law of affairs between them, my lord.
Law of affairs. Okay.
And then, when they both were signed up before the, after receiving the assignment, after fighting the assignment, they both.
Case for bail by may pass the bail order by the learned trial court below. At this stage, we do not want to interfere. Do not want to interfere. You just try, and if it is suppose in any reason it rejected, then definitely the door is open. You can come here. But,
Young boy, my lord, both are young boys, 21 years old.
pardon?
But this is this petitioner is young boy, my lord, 21 years old.
I can understand. Heard Mr. A. Kanikar, the learned counsel for the petitioner, as well as, and he also heard Mr. B. Sharma, the learned counsel, being on respondent. Case was with for case diary. It is submitted by Mr. Sharma. That case has already been charged by, yes.
Charge sheet number 3/2026, dated 27/1/26.
So, we are directing you to appear before the approach before the learned trial court below with an prayer for regular bail application. If in any case it is not considered, it may be a case for bail. You can very well approach this court. Suppose they surrender before the
They signed up.
both of
Both
them.
signed up. That's another
Love affairs.
deep level.
Here she did not receive, they are in interim mind.
CD not received. Reminder. Yes, when it can be.
By that, 5th of March.
Bye. Interim be continued till next date of receipt. We are continuing our interim. Yes, in 19, what is the position?
By that, here is also charge sheet submitted, man.
I'm on interim, Lord.
Yes, what is the CS number?
I charge sheet number 192 of 2025, dated 31/12.
You are an interim.
Yes,
You are Mr.
I'm Hassan.
M. Hassan. Back in Likidi Charge sheet number Swens. So we are extending your interim up to 15 days.
Yes, Lordship.
And within 15 days, you appear before the learned trial court below with a regular bail application.
Yes, sir.
That may be considered.
Yes.
Otherwise, we are extending your interim up to 15 days.
Yes, Lordship. Obliged.
If you want,
Here is also charge sheet submitted, ma'am.
Are you on interim there?
No, Lordship.
No, ma'am.
No interim.
No, ma'am.
Yes, number.
ICS number 776 of 25. 776 of 25 dated 22/12.
It interim 90.
Dated 22/12.
22/12/2010.
Ma'am. 25.
So as case has already been charge sheeted, you have to approach before the learned trial court below with a regular application for bail. That may be considered. And in case of non-consider, if it is not considered, then you can approach this. At present, you approach before the learned trial court below as case has already been charged.
Ma'am.
Interim 9 days.
22.
Please conclude, Lordship. I'm paying for the time being on behalf of Mr. S.C. Vishwas, Lordship.
Time being may be.
My lord, here charge sheet submitted also. Here also.
Your
ma'am.
case is already charged.
Fine.
You are on interim otherwise?
No, Lordship,
No.
I'm not on interim.
You are not on interim.
Lordship, kindly make it a short possible, Lordship, for the time being. Let my senior come and pass
This
on it.
bench only up to 1. Thereafter, it won't reach.
He will be
only-
coming right now. He is
Okay,
moving on
okay, okay.
before Kornapani.
Okay.
Great.
23.
Yes, 23. We have received this scan copy here.
Scan copy received, Lordship.
Okay.
164, 161, it's corroborated. Then in the medical report, Lord, hymen is torn at 5 o'clock and 7 o'clock. That is,
He's already married woman, Lordship.
he's married. He's married. She left her husband.
I filed one additional affidavit, Lordship, because they are in relationship in 2023, Lordship. So monetary transaction between them was
You have already filed your affidavit?
already filed, Lordship.
Acha.
Have a look, page number, Lordship 23. Sorry, Lordship. First, you see the page number 20, Lordship. Para number 3, I mentioned the phone number of the informant, Lordship, which was already mentioned in the FIR first page, Lordship. 12 number page, Lordship. It's
Now, what do you want to submit? They were earlier in relationship.
Lordship.
She is a married woman.
Lordship. After that, she also want to marry the petitioner number 1, Lordship. Because of that, Lordship, because he already married, she already married, Lordship, and judicial separation is not there, Lordship. No divorce or decree, anything is not happened, Lordship. So that's why she wants some time. But she went to her home, went to his home, Lordship, and then after amicably settled that matter on that day, Lordship, on 2025, Lordship. After 3 days delay, Lordship, she filed a false case against the petitioner number 1, petitioner number 2. He is a friend of the petitioner number 1, and mother, the accused number 4, already got bail and lower court, Lordship. At this moment, Lordship, because the matter is charge sheeted, he want to face the trial, Lordship, and one protection may be given on that, Lordship.
Yeah, he is shown as an absconder.
Because of he's not a peer, because he is not protected, and he filed before first anticipatory bail before the additional section judge Bilashipara, then file before this honorable court, Lordship. Because I'm not protected, that's why I'm not appeared before that, Lordship. That's so charge sheet may be absconder shows, Lordship.
Then after the rejection of those two anticipatory bail applications, you have not appeared.
No, Lordship.
Now you're appearing. Again, seeking that you are going to bail her.
Lordship, the payrolls are 164, now it is 183, Lordship. They have a love relationship. It is 5 years. have called one of his another friend. Both of them have
It is true.
these two boys. That is the
Lordship is not happened, Lordship.
when she made hue and cry. Then her parents recovered her from that house. She was recovered from the accused.
Lordship, I mentioned, have a look, my
164 and 161 is there. I have flagged.
Lordship, have a look, page number 4, Lordship, para number 3, Lordship.
That is your case.
Lordship, I'm to
Both of you are shown as an absconder in the chart.
Lordship.
RMS. You are also A become, you are not A become.
Lordship, I have seen another thing, Lordship. Have a look, Lordship, page number 54, Lordship.
54.
October 17, 2025, Lordship. The Khairul Islam, the petitioner number 1. Page 2, Afruja Begum. Afruja Begum is the informant. This is the 17th transaction. Then 53 page number, Lordship. Have a look, last, Lordship. October 20, 2025, Lordship. Received from Afruja. Afruja again back to the amount, Lordship, 8,000. Time is shown, Lordship, 10:33. Lordship, because it's all completely false cases, Lordship, because
Why monetary transaction?
Lordship, just because boyfriend girlfriend, that's Lordship, because the informant want to marry the Khairul Islam, Lordship, because already she is married, Lordship. There's a false case lodged against the petitioner, Lordship, and the settlement was have a look, Lordship. I'm the petitioner number 2 is a friend of the
petitioner number 1, and well wish lordship, after due counseling, the petitioner number 2 is present on that meeting, lordship. That's the informant implicated the name of petitioner number 2, lordship.
The case has already been charged. We did not go detail of the merit of the case at this stage. Only thing that what was your conduct. Anyway, you are MSA Begum.
A Begum.
Heard MSA Begum, learned counsel for the petition, and also heard same MSA Begum, the learned additional PP appearing on behalf of citizens. And this is an application under section so and so in connection with so and so. Scanned copy of the DCI has already been received. Otherwise, what is the stage of the case? It's the appearance stage.
Appear.
It is submitted by Ms. Begum, the learned counsel for the petitioner, that the present two accused petitioners are innocent and they have not committed any such offense as alleged in the FIR. However, it is a fact that the accused petitioner number 1 had love affairs with the victim informant, and she insisted him to marry her. Though they were in relationship, but as she was a married lady and did not get any divorce decree from her earlier husband, he could not accept the proposal of the present proposal of the victim informant. And on his refusal only, the FIR has been lodged with some false and concocted allegations. She further submitted that they had a love relationship and were also in relationship, and she also annexed some documents where it is also seen that there was some monetary transaction between them also. Further said that the matter was also amicably settled, but in spite of that, the FIR was lost by and A Begum, MS A Begum further submitted that he applied for the anticipatory bail before the learned session judge, and on rejection of the earlier anticipatory bail application, these petitioners also approached his court with an anticipatory bail application, but as there was no interim protection, they could not appear before the IO as there is possibility of arrest of these two petitions. However, at this stage, both the petitioners are ready and willing to contest the case by appearing before the learned trial court below on each and every date to be fixed by the court. MSA Begum, the learned additional PP submitted in this regard that is this is not a case of gang rape wherein she brought the allegation of rape against her by both the accused petitioners along with one other. It is the case of the petitioner informant that the day of incident, a promising to write a job, she was picked up and took to the house of Khairul, that is the petition number 1, wherein these two petitioners along with one other committed the offense of rape, one by she further submitted that from his her statement made in 161 and 183. Her statement made before police, and also her statement recorded under 183 are corroborating, and from where also it is seen that they committed such kind of offense. However, she admitted that it was that the petitioner as well as the informant had some love relationship, which is not denied by her. But the day of incident, they took her to the house of the accused number 1 and committed MS Begum accordingly raised payment objection and submitted that it's not case for anticipatory bail at this stage. hearing this submission made by the counsel. First, the case record and a scan copy of the record as well as the diary, which is received from the trial. It is seen that case is already translated and these two petitioners are shown as an absconder in the charge sheet as they did not cooperate in the investigation of this case, and in spite of several attempts, they could not be apprehended. From the submission made by learned counsel for the petition, also it reveals that they did not cooperate with the investigation, and as their anticipatory bail was not considered by this court as well as the court of sessions. Thus, from the entire record as well as the submission made by learned counsel for both sides, it is seen that during the entire period of investigation, these two petitioners avoided the police arrest, and for which their custodial interrogation was not possible, and both the petition had to be shown as an absconder in the charge sheet. Considering the all taking into consideration all aspects of the case, I do not find it a fitness to extend privilege of pre-arrest bail to these two petitioners. Same stands. Your petition stands
Rejected, Lordship.
rejected.
Lordship has last time, just I want last time.
No, I have dictated the order. So that can be a submission. Yes, Mr. Biswas.
Yes, I will appear there and pray for regular bail. So interim may continue.
Interim was there?
There is interim.
Interim was there? Interim was there.
Yes. 9/12.
Acha, interim was there. Okay. Same order. Yes, charge sheet number.
Case number, Lordship, 50/2025, dated 21/12/2025.
We are going to extend your interim for 15 days.
Yes, kindly extend it. I will appear and pray for regular bail.
Okay, sure. Okay, we are extending.
Development.
May
Yes, what is the
review
position here?
for my lord.
CD receive, my lord.
CD?
FIR, my lord, vernacular, page 12, my lord. Allegation is rape.
Vernacular?
12. Allegation is rape, my lord.
Yes.
May I read, my lord? Written in Bengali language, my lord. গৃহীত নিবেদন এই যে গত 16/12/2025 ইংরেজি তারিখ রাত্রি অনুমান 9 ঘটিকায় আমার গৃহের টিনের জালানা ভাঙ্গিয়া প্রবেশ করিয়া আমি শুয়ে থাকা অবস্থায় আমাকে মুখে হাতে দিয়ে চাপা মারিয়ে আমাকে ধর্ষণ করে ও একখান ডেগার দিয়ে ধমকি দিয়ে আমাকে বলে যে হাল্লা চিল্লা করিলে মেরে ফেলবো। ও আসামি আমার সাথে প্রায় আধা ঘন্টা দর্শন করিয়া চলিয়া যায়। আমি তারপর চিৎকার করিয়া স্থানীয় আমার শ্বশুর শাশুড়ি আসিলে ওনাদিকে বললাম ওনারা আসামির বাড়িতে গিয়ে আসামি পান নেয় যাতে আজ 17/12/25 আপনার আশ্রয় দাঁড়িয়ে is the allegation. When he was entering the house, breaking the window, he was silent, my lord. When Akush was entering house, my lord. Thereafter, after committing offense, then he went crime, my lord. And actual fact, my lord, actual fact is, my lord, I have stated in paragraph 4, my lord. The informant husband Amanuddin, my lord, he took money from Akush person, my lord, 35,000, my lord, as a loan, my lord, for my lord. Then when he asked to pay the amount, my lord, then some altercation was there in the marketplace. After some
Some days after a week, my lord, therefore he filed the FIR, my lord. That is the main fact, my lord. Even, my lord, he informant, he did not know the name of the accused person, my lord. Actual name is Tafazul. He filed the complaint against Jamaluddin, my lord.
When?
Jamaluddin.
Then why you are appealing? Why you are apprehending?
No, it's my nickname, my lord.
Nickname?
My lord.
Actually, you are?
Tafazul.
Tafazul. Alias Jamal.
Jam. Possible?
No, you are not challenging the identity.
No. Lord, CD is there, Lordship. The CD.
Here I have received the case there, madam. From the 183 statement of the victim, madam. May kindly peruse the her statement, madam. It is clearly stated that because he was the person who involved in the offense, madam, heinous offense, and taking the with the help of my lord Dow, while he is also Degar, my lord, along with Degar, my lord, and taking the my lord Degar, he also entered the house of the my lord victim, my lord, therefore committed the offense. That is there in the 183 statement.
Now, see, from her statement, it is seen that more Laura Swali petition, not distribution. The learned additional PP appearing state respondent. This is an application when swift connection. Did you receive? Next one, Mr. Azad, the learned counsel for the petition submitted that the statement made in the FI itself is seen that a false and concocted case is brought against petition. She remained silent when the accused petitioner had broken the window of the house, entered into their house, and further she remained also silent for half an hour, and then only she screamed, and then her other family members and the local persons arrived. He further submitted that the actual fact of the case that the husband of the present informant took a loan of 35,000 from the accused petitioner, and when he demanded back his money, there was a quarrel, and only to avoid only for that reason the present affair has been launched with some and complication. However, he is ready and willing to cooperate in the investigation of this case if he is granted with the privilege of the arrest. Next, Mr. Sharma, the learned additional PP submitted that from the available materials on the case diary, especially from the statement made by the victim under section 183 PNSS, it is seen that she was it is seen no further it reveals that the accused petitioner could be identified, and he is the person who committed rape on her on the night of incident. Accordingly, he raised objection and submitted that this may not be a case for anticipation. Next, para hearing this submission made by I have also fixed the case diary, and considering the materials in the case diary, I find that custodial interrogation may not be necessary for the interest of the investigation, and hence I find it effective to extend the privilege of pre-arrest bail to the present petitioner with a direction to suspension. Pre-arrest bail to the above dissatisfaction. Okay, will be granted with the plea.
Obliged.
Yes, what is the position of 20?
My lord, CD receipt.
CD.
CD.
May I please, Lordship? In this case, my lord, our affair may kindly be seen at first, my lord, at page 17, your lordship. Kindly.
You have also
Um,
lodged an FIR.
Yes, my lord. That is the fact of the case, my lord.
Okay.
May I read, my lord? With due respect, it is stated that the accused number one is my brother-in-law, and my elder sister was married to the accused number one about 15 years ago. But after marriage, the accused number one, accompanied with his brother, has been torturing my elder sister both physically and mentally. It is pertinent to mention that the accused number one, after marriage with my elder sister, married another one illegally. But the woman went away due to the torture by the husband, but not stopping at that point only. The accused number one maintained an illegal relationship with a woman for the last 8 months and lived at Gauhati. It is informed to you that from the day before yesterday, both the accused persons started for torturing on my elder sister. It is learned that yesterday the accused persons assaulted my elder sister, and today also. After children went to the school, the accused persons badly beat my elder sister. It is pertinent to mention here that the accused number one informed me about 12:30 noon that my elder sister has a consumed poison and accused number two is taking my elder sister to Hazo FRU hospital. But due to serious condition, my elder sister was taken to Norvik hospital at Hazo, but the doctor declared him dead. At that time, both the accused person did not allow me to enter into the hospital. Therefore, it is suspected that both the accused persons together killed my elder sister by beating and thereafter tried to circulate the incidents as suicide as if poison was consumed. Thereafter, therefore, you are kindly requested to take necessary action, my lord. This is the fact, my lord, depending upon which, my lord, the petition number one has lost this affair, alleging that his elder sister-in-law is alleged to have been committed murder by the brother-in-law, my lord. This is the allegation which has been lodged by the present petitioner, my lord, who is made the accused in the present case, my lord. And now the FIR lodged by the informant, my lord, against us, the present petitioners, my lord, where the petition number 1, 2, and 3, the accused number 2, 3, and 4, my lord. At page 9, your lordship can see the FIR lodged by them, my lord, against us, my lord. The first portion is not connected with us, my lord. The later portion, the last half of the FIR is, my lord, the allegation against us, my lord. May I read, my lord? At page 9, the bottom two lines from 2 lines. Thereafter, accused persons mentioned above have been threatening in different sorts and at about 1 noon, equipped with deadly weapons in their hands, unlawfully entered and destroyed our houses, and moreover, they have stolen money, jewelry. Not only stopping in that, also they also with about 10 to 15 miscreants went and about 6 p.m. set fire in our houses. As a result, houses including numbers and other household tools, along with the documents burned in the ashes, my lord. This is the allegation against us, my lord. The present petitioner number 1, that is the accused number 1, is the victim here. Uh, is maybe taken as the victim because his elder sister-in-law has been committed murder by the informant side, my lord. In this case, my lord. And that case also registered, my lord, under section of murder, my lord. Now, against our allegation is that we have set fire in the houses of the informant, my lord. This is the allegation, my lord. But so many persons were there, my lord. For the accused number 1 is we are not, my lord. Accused number 2 and 3, 2, 3, and 4, my lord. So after the occurrence of that incident, my lord, police came, my lord, to the spot, my lord, and on the verbal deposition or statement, my lord, our we
So
have
you are
been
the only FIR named accused person.
my lord.
Though you have stated that there are many persons gathered there,
Yes, ma'am.
but you are the only accused
My lord,
mentioned in the FIR.
Mentioned in the FIR, madam. Mentioned in the FIR.
And yes,
My lord, here I have received the case there, my lord. This is the second part, my lord. First time it was, he was consumed, died, whatever that is, my lord. That is defiant case was also lost, my lord. FIR lost. Here, this is the second part, my lord. After the death, my lord, all the family members of the, my lord, victim family came and set fire on the house of the, my lord, uh, uh, informant family, my lord. This is the case, my lord. Here, several witnesses examined. Even the, all of them, mama, my lord. All of the mama, my lord, from the statement of the, my lord, there, my lord. All of them came there and set fire on the house. Here, witnesses, my lord. There is the victim girls, my lord, who, my lord, that is the deceased son, daughter, my lord.
Girls,
Deceased daughter, my lord.
one who died, she's his daughter. Her daughter.
Daughter, my lord. And their 183 statement, my lord. They said that all the came to their house and all of them, my lord, set fire on their house, my lord. And they are even also said that they are not at present in the house, my lord, due to the threatening, my lord. From their
What had happened after the death of the girl?
my lord, all
they
that,
got
my lord.
related and
And
this time because these kind of things are now going on.
my lord.
But what
And
cannot take the law in their own hand. But still there is there.
but they are in the house, another person's house, my lord. They are due to the threatening from their, my lord, mama and family members. That is there, my lord.
This house belong to another person.
My lord, that is the informant, my lord.
No, but informant is the the informant is who is he?
Syed Ali.
Syed Ali.
Syed Ali, my lord.
And Syed Ali is the
father of the
father-in-law.
yes, ma'am.
Father-in-law.
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 Yes, ma'am.
Father-in-law.
Father-in-law of the deceased mother.
That means they are connected.
My lord.
And on the case, they are different person.
My lord.
So as per you, is there this custodial interrogation?
My lord, sufficient materials are there, my lord. Sufficient materials are, even the victim, my lord, girls, my lord, that is my lord, child. He also, 183 statements are there, my lord. And other witnesses also implicated, my lord. All of them come together.
My lord. But my lord, as information, my lord, they are not connected with the offense, my lord, and some other villages are there, my lord. So this is my humble
I
submission.
can visualize the situation because in such a circumstances, it happens. In TV also we are seeing that if some person died and some person
all the
died, all the villagers and come set fire and all these are things. I won't deny it. But the question is that you three are the FIR named accused. That is the case. So we'll do one thing. Let the statement be recorded because it is a case. Can visualize the situation, what had happened after the death of the victim.
My lord, in any condition, my lord, still in condition, my lord, my lord,
before that, my lord,
they will
kindly
cooperate.
page 183 statement of the daughter of the deceased, my lord.
How old she is? 16 years. So when they were inside the house, that happened.
My lord. And other witnesses also there, my lord. All of them came together, my lord, after the incident.
You are Mr. W. Rahman?
Yes, ma'am.
Mr. W. Rahman. Not part Mr. B. Sharma, the United Nations. It's an application section so and so in connection with so and so city. Next, submitted by Mr. The funds are concluded allegations has been brought against the present petitioner only as a counterblast as the petitioner number 1 had lodged an FIR after that. How he was related? Ashraf is the father.
Is the
Brother.
brother-in-law of the deceased, my lord.
Brother.
The brother of the
Brother.
deceased, my lord. Brother of the.
after date of his doc his sister, the date of his sister, as is the present informant as well as their family members had killed his sister and made broadly and raped his sister, and who stated to be consumed poison. But these three, but however, it is the fact that some of the people of that locality got furious and they had damaged the house of the petitioners, but the house of the informant, but these three petitioners are not at all involved in the offense and as offense, and only as a counter case, the present FIR has been lost, alleging the name of bringing the name of these three petitioners. However, they are ready and willing to extend their cooperation in further investigation of this case if they are granted with the privilege of bail, pre-arrest bail. Next paragraph, Mr. Sharma, they learned additional PP submitted in this regard that there are sufficient incriminating materials against the present accused petitioners, and from the statement made by the daughter of the deceased as well as the other victims, it is seen that these are the persons who came and set fire, set the and set on fire the house of the informant when even when all the family members were inside the house. Does it be saying that there may be involvement of some the other person, and hence the custodial interrogation of the present petitioners may be required to know the actual fact of the case. Mr. Sharma accordingly raised the main objection and submitted that this is not a fit case to extend the privilege of pre-arrest bail to the present petitioners. Next, hearing the submission made by learned counsel, I have also felt is that and the statement, especially the statement made by the witnesses as well as the daughter of the victim and daughter of the deceased. It is seen that from her, especially from her evidence, that these three petitioners, whom they could identify as well as her family members, came to their house and set fire on their house when they were inside the house, and somehow they saved their lives, but they could not save any household property. There may be a case where but it is so. However, it is a fact that an FIR was launched by the petition number 1 after after suspicious death of his sister, but for that reason they cannot take the law in their own hand and cannot commit such a heinous offense of setting fire of the household property as well as the property when the resident of that house was inside. When the resident were inside the house. Considering all these aspects of the case, the nature and gravity of the offense, I do not find it effective to extend the privilege of pre-arrest bail to the states. Hence, the prayer for pre-arrest bail stands rejected. Stands rejected.
Well,
The petition stands rejected. কি করো বাকি এটা তো নহব কৈ দিম নেকি এটা আছে এটাতো লৈ দিওঁ আৰু বাকী হিয়াৰিংটো আমি কৈ দিওঁ নিজিটো কৈ দিম এবি এটাতো লৈ দিওঁ এই বাকী এটাতো নহয় বুলি কৈ দিওঁ আছে নেকি আছে নেকি পলিমাটো দেখিছে আইটেম নম্বৰ 26 Sami kiba asil. 28. I think for 28 is part heard, na?
28 is part of, that is our.
But that matter may not be possible to take up the matter today because one matter you can see, item number 20. We have heard in three occasions partly. So last submission to be recorded today. So
If it is
it may not be
obedient to the court, man, we can have a short date.
Yes.
hearing day ki baat.
Because nothing much is left to be argued there, man.
Yes, on that day I have
I received
recorded
some
this stuff.
instruction. If it is acceptable to them, we can finish it here, or other way it will go back.
1/7. It's the hearing day. Hearing day is 1/7, 17. 17 of this month.
7.
Thursday or Tuesday? It's a Tuesday.
That means I have got other part of matters on 17th, any other day.
In that case, 19.
19th.
It will be 19th is okay.
Public.
Much of them.
So we are fixing it on 19 to
19 February.
19th.
Much of them.
The last item is a bail item
26.
26 is only left.
Here, CD not received, my lord.
May I please?
CD not received.
My lord.
Are you on interim here?
No, my lord. Basing on the facts, it is highly required to take the statement of the present petitioner, my lord.
No, whatever.
My lord, earlier not
Interim.
given interim, my lord.
What is the case about? In fact? It's a case of
Case of my
rape.
lord, outrage of modesty, my lord.
Outrage of modesty.
Attempt to rape, my lord.
Acha.
That is also there.
So
For
after
that-
perusal of the case,
My
there
lord.
My lord,
may
for
be a
that
case
make-
for it may be a case
My
for bail also. I
My-
can say at
my-
least. So
for that make,
CD
right.
not received. Issue reminder. When it can be fixed.
My lord, that is 19th, my lord. This 10th. 10/20, my lord.
Okay, then 19th.
19th.
You're saying 19th.
19th.
Published.
19 to proceed. Baki na yan. Actually, one
Lordship, I
matter
missed-
left that was we are hearing in 3 occasions.
Yes.
I don't know whether it will be finished up by today or not.
Yes.
Both
My
the
lord,
senior councils are there. So we'll try to finish it up by today because it's a part hard matter. 3 occasions we have already
My
had
lord,
as well.
during submission of item number 9, my lord, that is transit anticipatory bail, my lord, I submitted that Assam is now a hotspot of my lord,
Yes, I have recorded.
That, my lord, kindly may not be recorded, my lord. It is rapidly growing, my lord, alarmingly, but
Okay.
because hotspot, my lord, it will create, my lord, that word. not, that may
Okay,
not be
I'll
recorded.
delete. I'll delete. Yes.
May I
on
please,
sub-
Lordship, item number 14, I'm unheard,
14?
Lordship, due
It
to
is
my
already
cough and cold.
transported.
Due to my cough and cold, my Lordship,
Oh,
I
what
could not
to do?
respond.
Now you could have informed my
It was
court
very
master.
irritated, Lordship.
He wants to withdraw the matter, but
But then you make a mention for tomorrow
yes.
because it is gone, already gone. Case is already charged sheeted, na?
The
So
matter may
make a
be
mention tomorrow so that it can be listed before this court or wherever it can be withdrawn.
Hello.
This is number 93.
93. As an AD memory, Lordship, I can start with the page 91, Lordship. Though at the cost of repetition, Lordship, just as a AD memory, Lordship, I'll just show, Lordship, page 30 and page 31. Para 30 and para 31 at page 91.
Yes, I have already marked. Yes.
Yes, Lordship, the decree of eviction of dependent number to her man as an assigned and scheduled property of the plain. So they have asked for an eviction, not even asked for their possession, Lordship. It is not their case. They give us the possession because we are the owner, we are the title holder, not their case. So their prayer is just evict him. That's all. Then the second Lordship at para 31, last 4 line, permanent injunction, restraining dependent number to her man as from alienating and selling in the property. That's the final Lordship there. Nothing more. Then Lordship, page 93, Lordship. From 1, it is declaration, Lordship. So recording the name of Bandhana Medhi, Lordship. Not their name. They have not asked for their name. Because Lordship knows, Lordship, under the 34 specifically fact, they must have some right to file a suit. That is also not there, Lordship. And Lordship, the Roman 7 at page 95. Prayer, Roman 7.
Yes.
A decree of eviction of defendant as in so and so, so and so. Then 8, selling any property portion of the schedule A. That's the prayer. Now, Lordship, with this, Lordship, now let us go to the judgment pass. Because, Lordship, now, though a first bill is moved, Lordship, judgment is not even read, Lordship,
Read it.
properly, Lordship.
Yes.
So let us go to the judgment first, Lordship. That is at 421.
Yes.
Lordship, the 421, she started with the writing all the facts, what the plaintiff are good, then what the defendant are good. She has, yeah. Then, Lordship, while writing all the, she has noted everything, Lordship, what the plaintiff are good, what the defendant are good, all has here recorded. And then, Lordship, may please come to para 11 at page 434. Because that facts part, Lordship, otherwise also Lordship knows now, Lordship, after hearing the matter, the facts is written thoroughly, Lordship. What has the plaintiff has argued and what the defendant has argued.
Yes. 434.
Now,
Para 11.
434, para 11, Lordship. After perusal of the pleading of the both sides, it is found that the Schedule A property is the same as Schedule of the land in the impugned sale deed in the name of defendant number 1. Lordship will take note of this. The impugned sale deed executed by defendant number 1 in favor of defendant number 2 also mentioned the same schedule. But in addition to that, it also mentioned about the existing Assam type structure of so and so, so and so. That the plaintiff has denied the authenticity of the photographs filed by the defendant number 2, which shows there is a Assam type CGI structure in the admitted. At present, the plaintiffs are having access to the suit property. Is the pleading. The pleading of the suit and the... Yes, I'm reading para 12 only. No. After para 11, I'm reading para 12 now. The pleading of the suit and the instant miscase invariably shows that the plaintiff interfere with the possession of the defendant number 2. Lordship, take note. Yes. The pleading of the suit and the instant miscase invariably shows that the plaintiff interfered with the possession of the defendant number 2 during pendency of the suit. And after the arrest of son of defendant number 2 in connection of the criminal case filed by the plaintiff alleging thievery and the grabbing asset. Para 13, now the moot question. Now the question has come, the court. It's a beautifully written judgment, Lordship. Now the moot question is whether the plaintiff would have taken over possession or interfere with the possession during the pendency of the suit after admitting the possession of the defendant number 2 and praying for recovery of possession. Then a question mark. It is the court put the question to her. Yeah. On record, there is no injunction order against any party. There is no injunction order in favor of the plaintiff, even in the probate proceeding. Thus, absence of injunction order means the parties are free to change the admitted status of the landed property or not. It is a question mark. Now the court put a question mark that whether if the injunction order is not there in anybody's favor, but that probate suit injunction is against the plaintiff, where the court has held that the plaintiff is not in possession anyway. Which is a pleaded case in the plain. Probate case is a pleaded case in the plain. though the order is suppressed, Lordship. Now 14. Court has beautifully put the question and then given the answer. Para 14. The court will try to answer this question in the following paragraphs. It is a settled law that injunction is an equitable relief. A party seeking injunction comes to the court with a clean hand. The learned counsel for the plaintiff argued that the defendant number 2 earlier filed petition for recovery of possession and injunction and later on withdrew both and filed the instant application for injunction. The learned counsel thus argued that the defendants do not deserve any relief from the court. On the contrary, the learned counsel for the defendant number 2 argued that it is the plaintiff who abused the process of the law and took law in their hand and took possession, interfere with the possession by breaking the lock in a most illegal manner. Now, Lordship, this paragraph 15, it is the Dalpat Kumar 93 Supreme Court quoted. I'll read the language very slowly, Lordship, because this is the Supreme Court has decided and they put the nail in the coffin, Lordship. This is the judgment of the Supreme Court. Clear. Order 39, Rule 1C provides that a temporary injunction may be granted where in any suit it is proved by affidavit or otherwise that the defendant threatens to dispossess the plaintiff or otherwise cause injury to the plaintiff in relation to any property in dispute in the suit. The court may by order grant a temporary injunction to restrain such act or make such other order for the purpose of staying and preventing or dispossession of the plaintiff or otherwise causing injury to the plaintiff in relation to any property in dispute in the suit as the court think fit until disposal of the suit or until further order. Pursuant to the recommendation of the Law Commission, Clause C was brought on the statutory by Section 88(1)(c) of the Amendment Act 104/1966 with effect from the 1st February 1977. Earlier thereto, there was no express power except the inherent power under Section 151 of the Code of Civil Procedure 1908 to grant an interim injunction against dispossession. Rule 1 primarily concerned with the preservation of the property in dispute till legal rights are adjudicated. Injunction is a judicial process by which a party is required to do or to refrain from doing any particular act. It is in the nature of preventive relief to a litigant to prevent future possible injury. In other words, the court, in exercise of the power of granting an interim injunction, is to preserve the subject matter of the suit in a status quo for the time being. It is settled law that grant of an injunction is a discretionary relief. Lordship will take note of this. The exercise thereof is subject to the court's satisfaction that 1. There is a serious disputed question to be tried in the suit and that an act on the facts before the court, there is probability of this being entitled to relief asked for by the plaintiff defendant. Relief asked for by the plaintiff or the defendant. There is a serious disputed question to be tried in the suit and that an act on the fact before the court, there is a probability of being entitled to the relief asked for by the plaintiff or the defendant. 2. The court interference is necessary to protect the party from species of injury. In other words, irreparable injury or damage would ensure before the legal right would establish at trial that the comparative hardship or mischief or inconvenience which is likely to occur from withholding the injunction order is greater than that would be likely to arise from granting it. Now, Lordship, para 16, Lordship, now from here, Lordship, she has put the... So, Lordship, when the injunction order was read, Lordship, this paragraph, all this paragraph was not read by that is why I have read, Lordship. Otherwise, at the cost of repetition, I have not read all this. It's a beautifully written judgment, Lordship, that is what. Para 16. If we assess the factual matrix of the case, the following fact emerges. Now, she has jotted down A, B, C, D, all the following facts. Late Subhadra Medhi was the owner of the land. Defendant number 1 has registered sale deed in the name of executed by late Subhadra Medhi in 2008. These are factual aspects, Lordship. Defendant number 2 purchased the said land in 2022 from defendant number 1. Plaintiff's father, predecessor in interest, late Birabhadra Medhi, was allegedly bequeathed the land in 2015 by Subhadra Medhi, filed one registered deed. Probate case filed by late Birabhadra Medhi is pending. That is the PTS 5 of 2018. And Lordship will take note. This PTS was filed in the year 2016. It was numbered at Lordship knows before the probate title suit is registered, Lordship. It was registered as a probate miss case 12 of 2016. Probate miss case number 12 of 2016. Then after notice and Lordship in probate case, Lordship knows, Lordship. After that, then only Lordship it is probate title suit is registered. So in 2018, probate title suit 5 of 2018 is registered. And Lordship, here the dependent number 5 and 10 are a party in the probate suit. Defendant of the title suit, the present title suit, Lordship. And they have contested. And they have filed their written statement. They have also objected the injunction. And the injunction of the present plaintiff was rejected in PTA because of the defendant number 5 and 10 has objected to. Everything is suppressed, Lordship. Nothing is before the trial court. The defendant number 2 has mutation over the land, and defendant number 2 having possession of the land when the suit was filed by the plaintiff. It's an admitted position, Lordship. I have read the para, page 93, para 30 and 31. Everywhere it's an admitted position, Lordship, that I am in possession. Plaintiff prayed for recovery of suit land in the suit. It is the prayer. Prayer number Roman 7, Lordship, page 95. Plaintiff took possession of the land during pendency of the suit without the information leave of the court. It is also noted, Lordship. It is not that. Now posing here, Lordship. They have filed an amendment application, Lordship. Lordship may please come to posing here, Lordship. Lordship will keep here. Lordship, I will come again to this page 437. Lordship may please come to place 243. Annexure 22. Lordship will take note of it. Annexure 22, page 243. Yes. Page filed on 14/8/2024. Lordship, this is an application under provision of Order 6, Rule 17, read with Section 151. Lordship, get it. Lordship, we have filed our objection. Defendant number 1 also has filed an affidavit, and we have also filed an affidavit. Our affidavit is just on, we have filed on 17/7/2024 in the earlier year. That is also there, Lordship. But the now, Lordship, for this year, I will come to paragraph 5 of this amendment application. Page 255, sorry. Page 255, Lord. Paragraph 5, internal page 13 of the application. Right? Lordship, get it. Paragraph 5. That the applicant plaintiff intended to replace the paragraph 30 of the plain. Paragraph 30 I read, Lordship. Just now I have as an ready memory I read. That the defendant number 1 and 2 are the person of desperate character when unlawfully occupying the so-and-so. And the now lordship, in the earlier the plaintiff lordship will get, it is now here they have written where. Earlier it is our lordship. Lordship can check that lordship, but it is a matter of record. The schedule A land so-and-so, then the defendant number 2 were occupying the suit land and room which CGI tin sheet in the basis of purported sale deed dated 17/11/2022. This is paragraph 30 they say. Then para 6, it is if lordship will read this paragraph 6, lordship will take note of because it is the relevant paragraph. This was not read, lordship, so I have to read. That it is stated and submitted herein that after the arrest of defendant number 1, lordship will take note. That is stated herein that after the arrest of defendant number 1, as well as the son of defendant number 2, lordship, it is not the defendant number 2, son of defendant number 2 was arrested. The scheduled land was lying unattended. See the reason, lordship, why they have entered. The reason is here only. Lordship will get the reason only in this paragraph. The son of defendant, the scheduled land was lying unattended, and to protect the interest of the plaintiff from any third party, the plaintiff came into possession of the scheduled land. No date, no time, nothing. Court put that question, lordship. I'll read that. As such, in the sense circumstances, the applicant plaintiff intended to amend paragraph 31 of the plaint is as follows. Lordship, get it? Now, this is the amendment. Para 31. What amendment, lordship? That soon after the arrest of the son of the defendant number 2 with regard to Bhorolmukh police station case number so-and-so, the different case, and the further upon the cancellation of the mutation and all that, the scheduled land was lying vacant for a long time unattended, and to protect the interest of the plaintiff from any third party, the plaintiff came into possession of the scheduled land. As such, the plaintiff, their man as an currently in possession of the scheduled land. Now, crime is also admitted on affidavit, lordship, that we have done a crime and admitted on affidavit. They are so confident, lordship. They know that the Bhorolmukh police we are in our pocket, so they will not do anything. The police are pet, so they will not do anything. So we can write anything and everything before the court of law. I'll read a Supreme Court judgment, and I'll read a judgment of dishonorable court, lordship, where dishonorable court has sent the matter to the DGP and the chief secretary. That if this thing was going on in Gauhati, it was earlier in UP, earlier in Mumbai we heard, now it is started in Gauhati. And this court referred the matter to the chief secretary to look into all this type of thing with the help of the police. I'll read that judgment, lordship. Now, para 7. In view of the subsequent development after institution of the plaint filed by the suit, the plaintiff intended to amend following prayer in place of prayer 7 in the plaint. As such, the appellant intended to amend prayer number Roman 7 as follows. That Roman 7 at page 95, lordship, I read. Now they want to amend a decree of declaration of confirmation of possession of the plaintiff over Schedule A property to the plaintiff. Now, there is no recovery of possession, lordship. Even now, no recovery of possession. They do not want their title. They do not want their interest. Nothing. No right, no title, no interest. Only recovery of possession. So, with that, now what they want to do? They want a confirmation of possession. Now, lordship, all these 3 paragraphs I have read. Lordship may come to page 284. Right? Page 284. All these are rejected. And that attains finality, lordship, not been silenced. Lordship, it is the order is third at page 271. Lordship will take note that this order of 6/11/25 is third at page 271, annexure 24. 271, annexure 24. I'll not trouble the Lordship with all these pages.
Yes.
Lordship, may please come to page 284. Court criticized like anything in the order. I don't want to all read all that, Lordship. But this come to the finding, Lordship, page 284, para 21. While considering the proposed amendment relating to the sense in prayer of recovery to confirmation of possession in the light of the Honorable Supreme Court guideline and the admitted pleading of the parties, it is but apparent that the proposed amendment is not necessary to decide the real controversy of the suit. The plaintiff were never in possession of the suit land and before filing of the suit as admitted by them. Only after filing of the written statement, the plaintiff came in possession, that too without authority of law. This court has already ruled in Ms. case number 852 of 25 that the plaintiff cannot take the benefit of their own wrong and be allowed to continue with the suit land. So to allow the plaintiff to alter the prayer would only mean denial of admitted fact. It will prejudice the other side. Further, the proposed amendment will change the nature of the suit. There is a clear finding, Lordship. And Lordship, this order of 6/11/25 not challenged. It attains finality. And they file the amended plain also in by this order. In view of this order, file the amended plain also. Not been challenged. Come to the appeal, all these findings had not been challenged. Amended plaint is already filed in the court as per this order. Next para.
No, that's questioning. Amendment plaint is filed,
Fine.
but that prayer was rejected or what?
Yeah, no. With all this rejection, they have not put all these now. So amended plaint also, all these things are not there.
No, I am not on that. Thereafter, after filing their petition, they have inserted some prayers and they filed their amendment petition. Okay, prayer.
Not inserted the prayer. Whatever is rejected, it is not there in the amended plaint.
No. There was prayer. Initially, eviction prayer was, and subsequently confirmation poison, all those things they have inserted.
No. Amended plaint, all these things are not there. Lordship, for that, Lordship may please come to page 22. Because some of the paragraphs are allowed.
Oh, some allowed.
Some amendment, partly allowed. Some of the amendment allowed. These things were rejected. Lordship, am I clear, Lordship? Lordship, the what paragraph I have read?
Now, last para, page 284/21.
Yes.
Last line. So to allow the plaintiff to alter the prayer would.
Prayer is rejected.
That was rejected.
No. So in this prayer is not there in the amendment. Para 30, para 31, and para Roman 7. Prayer Roman 7 is not allowed.
That's what I'm saying.
So amended plain, these things are not there.
But after rejection of those prayers, they have, on the subsequent part, they have filed the amendment plaint.
Without those things.
Those prayers. Okay.
Now, Lordship, para 22, what is allowed, Lordship? It is there in para 22. Therefore, in my opinion, plaintiff prayer for amendment by way of insertion of so and so are allowed. So these are some here and there, Lordship, something is allowed. So that with that allowed portion, they have filed the amended petition. So now, Lordship, come to para 23. At page 285. Very clear. But proposed amendment of para 30, 31 and insertion of prayer Roman 7 are declined.
Yes, that will be clear.
So with this lordship, it is declined, and accordingly, lordship, the amended plain is filed. We have taken a copy. Lordship can just see, lordship, I cannot give in a first appeal stage, lordship. The 7 is the same thing is there. See what is earlier there. Para 30 and
Okay, the prayer
31
for
is
amendment of para 30, 31 and
and
insertion
the
of prayer
Roman
7.
7. So it is not there. So it is, this is the amended plain lordship. They have given a copy. It's a matter of record, lordship, it is there. There is no dispute, lordship. We have received the copy and they have filed it in the court, lordship.
Yes.
So if this is, whatever is rejected, it is not there in the amended. So as per the amended plain also, lordship, para 30 and 31, we are in position. As per the amended plain, as per the Roman 7, we are in position. And this amended plain is filed on 19 December 2025. This amended plain is filed before the court on 19 December 2025, wherein they have admitted my position again by on oath. Lordship get it. So, Lordship, now I will go to page 437 straight. Now,
Yes.
Lordship will take note 6/11/25 trial court order. Now, amended file, amended plaint is filed 9/12, 9. When? 19/12/2025. Amended plaint file. So there also my position is admitted. Now at page 437, Lordship, it is 6/11/2025. The court said plaintiff took possession of the land during the pendency of the suit without information and without the leave of the court. Now, there are 17 at page 438, 6/11/2025 order. Here I have to stop here and there, Lordship, and I have to take your Lordship to some pages. Now, para 17, Lordship will first line itself. The court write the above admitted fact. These are the para 16 are the admitted fact as per the pleading. So on the above admitted fact necessarily lead to the prima satisfaction of the court that the title deed in the name of the defendant number 1 was prior to the execution of the will. In the name of Birabhadra Medhi. The plaintiff will be entitled to the title over the land only after the will get probated. Now, Lordship, pausing for a moment, Lordship, may please come to page 38, that PTS order dated 30/11/2018, page 38 of the first appeal. Lordship will take note because this line, Lordship will get at page 38. Lordship, while taking note, Lordship will take note that this 30/11/2018 order starts at page 36. It is the annexer 2. So, Lordship, this annexer to page 36, it started And I am coming to page 38. And Lordship will take note of one thing. These all these orders and is not there in the place. They have suppressed. While we have filed our application, then only we brought all this. And then court came to know about it. In the FO, that fact is not there, but all these things are suppressed before the trial court. We bought it, all these papers before the trial court. Lordship, while reading page 38, last line of the first paragraph. Last line of the first paragraph. So there is no prima facie case, arguable case in favor of the petitioner. Petitioner is the plaintiff. Petitioners are the plaintiff. Plaintiff here. In the pre-decision, whatever. Now the plaintiff. They have entered into the suit. Secondly, the petitioner filed the petition claiming injunction pending disposal of the petition for grant of probate. Only when the probate certificate is issued in favor of the petitioner, then he would acquire an interest over the property involved in the probate proceeding. In such case, at present balance of convenience or inconvenience would not deal in favor of the petitioner. Moreover, when the petitioner has no right, title, interest and possession over the scheduled land, he cannot be any loss, less to speak of irreparable loss. It is the PTS lawsuit. And it's a rejection of injunction, and this also attains finality law. No appeal. There is no appeal. Against this also there is no appeal. They have admitted. They accepted. Now, Lordship, may please come to page 438. The plaintiff will be entitled to the title over the land only after the will get probated. Since they did not have any possession over the land and their title is yet to be decided, on the strength of the will, in the name of their father, the prima facie title vests to the defendant number 2 at this stage. Though the sale deed in the name of both defendant number 1 and 2 are challenged in the suit, the court will decide the validity of the deeds only after the trial. Lordship will take note of this line now. Now that day, Lordship, many things has been read. The affair, then Lordship, the Deputy Commissioner crime report, then the Deputy Commissioner's order, all that is read against me. I have not made a single word, Lordship. Why? Why? All those things were already nullified by this court. Now, Lordship, I am reading this line. And the trial court has recorded that. Trial court has recorded that. The Honorable High Court in WPC number 1582/25 has set aside the order dated 8/3/24 of the Deputy Commissioner Kamrup Metro, cancelling the mutation of defendant number 2 unilaterally and all subsequent civil action and consequences thereof. Everything is nullified, Lordship, the Gauhati High Court, sir. And Lordship, ever heard, Lordship, that a police station will decide? Lordship, in a trial court, Lordship, we were doing the challenging, the sale deed, challenging the will, all these things we are challenging in title suit. Even the court do not take the responsibility to look into the signature, to look into the veracity. Court send it to the authentic authority, that is the forensic department, Lordship, that look into it. They say all this evidence act is very clear, Lordship, who look into it, how the report will come, then cross-examination of the forensic officer who is given the report. All these things are there. There is a procedure, Lordship. So, even any consequential Lordship passed by after this 8/3/24 is also cancelled by the Gauhati High Court. So all this has nullified. And Lordship can see how fast they are. It was filed on a particular date and then wait, then decided within 2 months. Huh? Almost 2 months, 1.5 months, Lordship. Everything is done hurriedly. Horolmukh police station send it to DCP crime. DCP crime has looked into it. DCP crime send it to the deputy commissioner. Deputy commissioner has decided everything, then write a letter to the DCP crime. Everything happens. It's all fun. Just to take over the land, possession of the land. The registration of criminal case of forgery against the defendant and other in respect of the impugned sale deed does not automatically lead to the conclusion that the sale deed are false or fake. As the validity of the impugned deeds are under challenge herein, this case and the matter is sub judice, the plaintiff can have no better title over the land at present. Clear finding laws. Therefore, this court does not find that the defendant number 2 is having a strong prima facie case at this stage. Therefore, this court does find. I'm sorry. Therefore, this court does find that the defendant number 2 is having a strong prima facie case at this stage. So, prima facie case is decided. Why I am showing one by one, Lordship? 3 golden principles: prima facie case, balance of convenience, irreparable loss. And Lordship, the first appellate court, Supreme Court has now have cleared that power of the appellate court is circumscribed. And the court said what the, when and how the appellate court will interfere. When? Capricious, arbitrariness, all these, Lordship, perverse. Then Lordship has to give all these findings separately. First, Lordship to say there is no prima facie case. First, Lordship to say there is no balance of convenience. The balance of convenience against the defendant number 2, or it is in favor of the plaintiff. Then Lordship to give the reason in all this. First, prima facie, balance of convenience, irreparable loss. Then Lordship to says why this order is perverse, why this order is, what is the arbitrariness, why it is capricious. All these things have to first appellate court have to see. Because Supreme Court is very clear on that. I'll read on all these judgments. Now, Lordship, balance of convenience. Next paragraph. Para 18. While coming to the question of balance of convenience, it is reiterated that the sale deed in the name of the defendant number 1 is allegedly prior in origin. Lordship of 2008 in favor of defendant number 1. Only after the full trial, the court will come to a conclusion whether late Subhadra Medhi had any saleable right over the suit land prior to the execution of the will in the name of the Birabhadra Medhi. Now that is also the question. Though the plaintiff side has alleged that the defendant number 2 has introduced new fact in this injunction application without amending their pleading, be it noted that those facts are necessary corollary. Lordship will take note. Because many a time this was argued, Lordship. The pleadings are not there, then the subsequent development, all these things were here. The trial court has considered everything, Lordship. Now this part, Lordship will take note. I am reading at the cost twice, Lordship, at the cost of repetition. Though the plaintiff side alleged that the defendant number 2 has introduced new fact in this injunction application without amending their pleading, be it noted that these facts are necessary corollary of the subsequent event after filing of the written statement and counterclaim, whereby the defendant number 2 stood dispossessed or his possession is interfered with. It is the plaintiff's own admission of fact who is going to show that they are trying to sense the nature and character of the suit. So court come to a conclusion while deciding the balance of convenience. Now, Lordship, in para 19, court quoted the 39 rule 1. So, Lordship, the 19 is quoted 39 rule 1, para 20. The present defendant number 2 is also a counterclaimant. It is seen that the suit was filed on 16/8/2023. There is a typographical mistake, Lordship, not 25. Suit is filed on 16/8/2023. There is a typographical mistake, Lordship. Lordship can correct it. It is a typographical mistake, Lord. Nobody, because plaint is annexed, Lordship. Lordship can see. It is 16/8/2023 for declaration and recovery of possession. The defendant number 1's written statement was accepted on 4/12/2023. The defendant number 2 filed their written statement or counterclaim on 3/1/2024. The plaintiff number 3 lost the affair against the defendant in Vorolmuk QS 357 of 23 on 6/12/2023. Lordship, just few minutes back I said, Lordship, is pending for a long time. That suddenly, Lordship, within a month they have done everything. The son of the defendant number 2 was arrested in connection with the Vorolmuk PS case number so-and-so on 10/1/2024. The plaintiff have stated that they took over the possession of the suit land to protect it as it was vacant and lying unattended for long after the arrest of the defendant number 2. See the reason why they have entered. Now court has given the answer here in this paragraph. Lordship will take note. It was unattended, so the plaintiff entered. The court has given the answer beautifully, Lordship, here. In that case, alleged disposition or interference with the possession of the defendant number 2 happen after the filing of the written statement and counterclaim by the defendant number 2. The plaintiff has filed an amended application by Ms. case number 759 of 2024 on 14/8/2024. I have read that, Lordship, just now. That amendment application, Lordship. I have read. Lordship has seen. To bring in the amendment to incorporate fact related to them taking over possession during dependency of this. I have read, Lordship, that amendment application, Lord. Now court has come to the conclusion. This fact necessarily shows that the balance of convenience is lying in favor of the defendant number 2, whose possession was interfered with by the plaintiff after filing of the pleading, wherein the defendant number 2 counterclaimant has sought for confirmation of possession. Lordship will take note. Why balance of convenience is my favor? The court has given a reason, Lordship. If the first appellate court have to sense the Lordship, because Lordship knows injunction is a discretionary relief, Lordship. And it is the first court has given the reason, and the first appellate court, first appellate court want to substitute it for any reason, because it is capricious, it is here, these all three, then only court have to give their own reason, Lord. This court may have some different view. On that ground, Lordship cannot sense this. Though the plaintiff in the written statement against counterclaim on 27/3/2024 denied the possession of the defendant number 2 over the suit land, that denial was in fact against their admitted claim. Lordship, now the court has given the finding. Suit land, that denial was in fact against their admitted claim in plain in para 30 and 31 and prayer portion, etc. Now, Lordship, I have said, now they have filed the amended plaint also. In the amended plaint also, that para 30 and para 31 and Roman 7 is there. Then, now they have shown a judgment on contradictory stand. Whose contradictory stand, my lord? It is your contradictory stand. In the plaint, you say in para 30 and 31 that they are in possession, give us the recovery of possession. Now they say that the only not recovery of possession even,
Only eviction.
Eviction, only eviction, Lordship. They cannot ask for recovery of possession. They are not the owner. They have no title, nothing. So where from they have come, I do not know, Lordship. I have doubt, Lordship, because he is the son of third wife, Lordship. The owner is the wife of third wife. And whether it is the half blood, Lordship. They have taken a stand in the written statement in 130, Lordship. Title suit 130. It is also to be noticed that the plaintiff or their father were never in possession of the suit land. Lordship is a direct finding, Lordship. Court has given. It is also to be noticed that the plaintiff or their father were never in possession of the suit land and have no mutation. Mutation obtained by defendant number 2, those suit cancelled on 8/3/24 after filing the criminal case against them. The Honorable High Court has set aside the order cancelling the mutation and consequent civil consequences. And High Court order, Lordship, has finality. They have not gone to the Supreme Court. They have not gone to the division bench. Now the best part of the judgment, the next line is that the arrest of the son, when the mother is there and the property is unattended, something another. See, owner is there outside. The owner of the land is Sarita Division, is outside. His son was arrested, put into the jail, and said that was unattended, so we have taken. So the court has written the next line. Good stand, Lordship. They tried well, Lordship. The plaintiff contention that the suit land was lying unattended after the arrest of the defendant's son is misleading. Arrest of a person in a criminal case does not divest him of the immovable property overnight. He was arrested, the Elaka magistrate has given him bail within 24 hours. So the word is overnight, Lordship, because he was kept in the police station overnight, just to took over the property. Paid money and then said, okay, keep him on the lockup. Let us take the position overnight. In fact, defendant number 2 had obtained pre-arrest bail when defendant number 2, Lordship, the court has written very clearly. In fact, the defendant number 2 has obtained pre-arrest bail while defendant number 2 is still alive and she had possession of the land. She could not have been illegally dispossessed as done by the plaintiff. Lordship, now the affair is under silence, Lordship. My learned, they were also made party in that. Lordship, in the criminal petition 510/2025. Listen. Last order. They were a party. So it is under silence, Lordship, all this affair and all that. Affair I'll read, Lordship. If Lordship will read the affair, Lordship will not believe. But the point is I have to read that affair. I do not know who has drafted that affair. The PTS case was suppressed. Title suit was suppressed. Nothing. That a civil matter is pending. Not a single word in there, fellow child. Let us, pausing for a moment, let us go to the affair. Because there should be some limit. It is nothing but a forum shopping, Lordship. Going to the CGM first, not get the order, complaint case, then a title suit, then a PTS, nowhere getting anything, then an affair. Doing what? Suppressing all these. That the PTS is pending, civil suit is pending, everything is suppressed and filed an affair and they were arrested. Let us see the affair. Page 184. Lordship get it. So affair 184, Lordship will get their affair at page 188, Lordship type 4. Lordship will see the subject. With deep subject, Lordship, any police officer can do this. I'm out, Lordship. See the first word of the subject. This is the action of the police when there is an act, Lordship. A statute is there. Then the police is doing. Lordship, read the subject first word. Land grabbing of so and so. There is a land grabbing act, Lordship. And Lordship know the procedure. Where they have to send the affair. Nowadays, Supreme Court has stopped the giving biscuit to the street dog, Lordship. So this type of dog has come out, Lordship, to take the biscuit from the people, Lordship. Even Supreme Court stopped the giving biscuit to the street dog, Lordship. Unfortunate, my lord. Unfortunate, this is unheard of. Supreme Court is stopping giving biscuit to the street dog. And these street dogs are getting the biscuit. So this affair, Lordship, page 188, 189, 90. Lordship, I will not read the whole thing. Nowhere, Lordship will get the fact. Lordship will take note. This is filed on 1/12/2023. After filing of everything. After filing everything. When they do not get anything here, when do not get any here, forum shopping, there should be some limit, Lordship, of forum shopping. When they cannot manage everywhere, they tried everywhere, they failed. They started forum shopping, here. Then they go to Forulmukh police station. Now this is, Lordship, I have just referred, Lordship. Lordship will read. I will not read at the cost of repetition, Lordship. There is not a single one. Not a single word, Lordship, that what happens before filing this affair. Now, Lordship, I am on page 441. Lordship may come to page 442. Line about 7 from the top, Lordship. Page 442. At page 442. Line about 7 from the top. Further, the plaintiff cannot be allowed to remain in possession and it will amount to allowing a party to take benefit of his own wrong. In fact, Mizze case number 824 of 23, it should have been 820, it is not 25, Lordship, all this is typing mistake. is 23. 824/23. The plaintiff, while admitting possession of the defendant number 2, have prayed for temporary injunction restraining the defendant number 2 from alienating the suit land and proceeding with the construction over the same till disposal of the suit. Lordship may please come to page 173, para 30. Lordship, because the number is here something here. So Lordship may please come to page 173, para 32. Started it with this good. Lordship, the miscase started at page 156, annexure 9. Lordship get it. Then Lordship may come to page 173, para 32. Top line, Lordship, that the opposite party number 2 is presently in unlawful possession of a certificate. In the miscase also it is admitted, Lordship. And what is the prayer in the miscase, Lordship? Let us see. The addendum temporary injunction restraining the opposite parties, their man agents from alienating and selling any part there. Now, Lordship may please come to page 442. In fact, in Mizze case number so and so, the plaintiff, while admitting the position of defendant, have prayed for temporary injunction restraining the defendant number 2 from alienating the suit plan and proceeding with any construction over the same till disposal of the same petition is pending. Now, para 22. The said precedent pending. If the plaintiff were really worried about the protection of the suit property, if the plaintiff were really worried about the protection of the suit property, they ought to have moved an appropriate application before the court for the same, instead of taking his possession directly without the leave of the court, and their action cannot be allowed to be perpetuated. The petition is still pending. The problem is, Lordship, always while arguing this type of case, back of the mind, there is some against the police, authority, always there, Lordship. Even I do not say that my client is a saint. I am not saying for a moment, Lordship. But at the same time, Lordship, this is a system, Lordship. Yeah, unfortunate. Para 22. Considering the above fact and circumstances, the court hereby direct plaintiff to keep their hand off of the suit property and not to interfere in possession of the defendant number 2 till disposal of the suit. Till when? Till disposal of the suit. This is when, Lordship, on 6/11/2025. Now, the plaintiff, their agents, men are hereby directed to remove all banners, fixtures, any movable kept by them in the suit premises after their unauthorized entry from the suit property. So this is the final order, and against that, this appeal. Again, this is the order, Lordship, and against this order, the appeal. And most interesting part, Lordship, while filing this appeal, something is argued, Lordship, that the doctrine of Marzar and all that. This is an appeal FO75 of 2025. Along with this appeal, Lordship, there is an application under Order 41, Rule 5, not pressed. No order. Lordship can see there is an application under Order 41, Rule 5. It was not no stay order, nothing. Order 41, Rule 5 application, they filed along with the appeal. It was not traced. There is no order. The IA number is 3829 of 2025. IA civil number 3829 of 2025. They are happy. When they got this status quo order, they are happy. Somehow, Lordship, they got the status. Oh, relief. Let us try to dispose them at the night because police touches us. And so we can do anything. So this Lordship will take note. There is nothing, no stay order of the interim order. But on 611 order, there is no stay order. It was not stay. Now, Lordship, in my IA, Lordship, I have filed an IA.
Yes.
Here in this case, Lordship. The IA is 95 of 2026. And in 95 of 2026, they filed their objection.
Yes.
Lordship, please come to page 64 directly. I don't want to read everything, Lordship, because what I want to do, I have done, Lordship. I know, Lordship, there is nothing more to do. Still, Lordship, sometimes to put the last nail, Lordship, of the copy. Page 64, Annex 5, Roman 5. It is on 8/11/2025. This is an information to the police station, and it was received by the police station on 8/11/2025. So, Lordship, the date is 8/11. Lordship will take note of two dates. My injunction order is 6/11. 6/11/2025. This is 8/11/2025. And the High Court status quo order is 26/11/2025. I'll go through. Now, Lordship, I have read the 6/11/2025, Lordship, just now. Now, Lordship, the High Court order, status quo order, Lordship, in the FAO, my miscase, Lordship, will get it at page 60. My IA 95 of 2026. Or Lordship, in the file also, Lordship will get it. What is the order passed on 26/11 till the next date of listing? Till the next date of listing, both sides are directed to maintain status quo as regard to the sued land as on today. That is 26/11. Trial court 6/11 said, you hands off from the property, don't enter. Then, at the time of hearing, we have shown the court all the photographs that we are in property. So, Lordship, please take my case, IA number 95 of 2026 for a moment. IA number 95 of 2026.
Yes.
Indeed, that Lordship order, Lordship will get at page 60 and 61, High Court order. 61, page 61, last line, Lordship. Page 61, last line, Lordship. The photographs given by the respondent shall form part of the record. The photographs are there from 62 onward, Lordship. And Lordship can see these are GPS photo. Time, address, location, everything is there. This is GPS photographs, Lordship, inside the property. And we have given the videos also, Lordship, and we have now filed our Lordship application under Order 65 rule supporting that. Lordship, they have given their objection to that. Now, coming to page 64, Lordship, for a moment, of their objection to our I. page 64, Annexer Roman 5, objection to IA filed by the appellant, opposite party. Now, Lordship will take note. This is 8/11/2025 file. The appeal, first appeal, is filed on 21/11/2025. Lordship will take note of the date. First appeal, FAO, is filed. FAO 75 of 2025 was filed on 21/11/2025. Along with the FO, there is an IA dated the number IA civil number 3829 of 2025, filed on the same date, 21/11/2025.
That has not been pressed.
This 8/11/2025 is not pleaded. Nowhere. Not annexed, not even a pleaded case. Because as per their FO, we are in position. Amended plane is much after Lordship. Even the amended plane, now they have said that we are in possession again. Para 30 and 31. And the prayer. Because prayer is recovery position, Lordship. Now, Lordship, if this document is there on 8/11/25, there is no pleading in the FO, there is no pleading in the IA number 3829. This is a fabricated document. But at the same time, let me take some benefit from this document because it was annexed on affidavit, Lordship. Because if this document is there, it's good, my lord, for my client, Lordship. Because on this document itself, my eye has to be allowed. No, Lordship, do not have to go to any other document. Lordship, let us read. 8/11/2025. I will just read from the top, Lordship, 7th line. When I was out of station at about 6:45 p.m., one Sangeet Jain, son of Sarita Devi Jain of Atgaon, has forcefully entered into my premises with some local goon, as my caretaker so-and-so tried to question them as to why they were forcing into the property and damaging the main gate. The goon, upon the instruction of the Sangeet Jain, had threatened my caretaker of their consequences and has manhandled him in the way of pushing and pulling him and misbehaved with him. My caretaker, being a young and unarmed, had called me up and informed me about the incident. By then, the goons and the Sangeet Jain already has damaged the CCTV setup installed by me over the property for its safety and had damaged the electrical connection and my meter box. Sarita Devi Jain has also accompanied the local goons and the Sangeet Jain, supposedly her son. Now the last 3 lines of the second paragraph, next paragraph, my lord. I will not read the whole paragraph. Whole paragraph is not recorded. I somehow managed to reach back my residence today, and out of fear of life and security, I am not being able to enter into the premises of my property. At least 8/11/2025, Lordship, there is an admission, Lordship. After 6/11, injunction order. Now they are admitting, Lordship, that my client was in possession on that. It is their admission, Lordship, not mine. I have given all the photographs, everything, Lordship. Now they have admitted himself and kept the goons in the property. Lordship, not only that, they have gone further. Sangijan has kept the goons in the property and has locked the gate from inside. What is the problem, my lord? After 2611, court said you hands off from the property. Don't come into my property. I'm already 611, court has passed that order. And I'm already there 811, it is 811. Now you are 811. Now you are trying to just after filing my miscase lordship, now this story. This is not a part of the first appeal. This is not a part of the order 41 rule 5. Though it is 8/11/2025, they have given a date. Sometime Bengali there is a saying lordship, Odikshana Golai Fasin, something like that. Bengali. It's like that only. So this is their reply and this is their admission lordship in the miscase. So this facts, any other fact? You want? Huh? Now, lordship, that day lordship, that day we have filed an affair and all that. It was not registered. It was not registered. Then we moved the CGM. Now, lordship, in the CGM, they have given a report that they have registered the affair. And lordship, it was the report. Accordingly, lordship, the magistrate has disposed of the matter, lordship, because the Holmok police station has said we have registered it. So lately, lordship, anyway, lordship, when we have moved the CGM, lordship, now they have registered. What we have informed that they have entered into the possession again. After this status quo order passed by this. And lordship, under that circumstances, lordship, my IA in this FAO is filed out. And my IA prayer, lordship, will take take note. My IA 95 of 26, lordship. The my IA, there is a prayer, lordship, at page 29 to 33. Page 29 to 33. Injunctive so and so, already there, lordship, but I'm showing this because I filed an IA, lordship. Though they have filed an order 41 rule 5, they have not traced because lordship, they are powerful man, lordship, they can do anything and everything. After taking a status quo order, I cannot, lordship. That's my problem. That's not my problem, my client's problem. In Kumarpara, lordship, I can do. So, want to do this, lordship. Now, lordship, I'll do some judgment of. Okay. So I have given two sets of EA lordship. One is for the FAO, one is for the IA lordship. I have given the index for both. And I have also flagged the things. Lordship, the one is the owner. No?
Yes.
Owner is the one, lordship. There is flag is there, lordship. Lordship may straight come to para 14. I will not read the whole thing. Owner, long as many things has been said on the appellate court, EA lordship. I'll only read para 14, lordship. I'll not take much time, lordship.
Yes,
Para 14 at page 733. Lordship, may I read? The appeal before the division bench were against the exercise of discretion of the single judge. Now, dear lordship, the single judge has passed the order. So division bench is in the appeal lodge. Here the trial court has passed the order, lordship is on appeal lodge. In such an appeal, the appellate court will not interfere with the exercise of the discretion of the court of first instance and substitute its own discretion, except where the discretion has been shown to have been exercised arbitrarily or capriciously or perversely, or where the court had ignored the settled principle of law regulating grant or refusal of intellectual injunctions. Here in my case, Lordship, I have read the every paragraph. Where prima facie case balance of convenience irreparable loss, clear. Then Lordship, why the order is passed, clear. An appeal against the exercise of discretion is said to be an appeal on principle. Appellate court will not, Lordship, get it? Appellate court will not research the material and seek to reach a conclusion different from the one reasonably possible, one reached by the court below, if the one reached by the court was the reasonably possible on the material. Lordship, this line I have to read again. Appellate court will not reassess the material and seek to reach a conclusion different from the one reached by the court below, if the one raised by that court was reasonably possible on the material, as in our case law. She has dotted the thing in para 11, para 16. She said that I have to decide all this. I have gone through all this material on oath. It is a oath versus oath, it is also said. The appellate court would normally not be justified in interfering with the exercise of discretion under appeal solely on the ground that if it had considered the matter at the trial stage, it would have come to a contrary conclusion. If the discretion has been exercised by the trial court reasonably and in a judicial manner, the fact that the appellate court would have taken different view may not justify interference with the trial court's exercise of discretion. After referring to this, the principle in so-and-so versus so-and-so, the principle are well established, but as has been observed in so-and-so versus so-and-so, the law as to the reversal by the Court of Appeal of an order made by a judge below in the exercise of his discretion is well established, and any difficulty that arises is due only to the application of well settled principle is an individual case. Or push. Now, Lordship, I don't want to read all other paragraph because in the serial number 2, these has referred, and in the serial number 2, again, Lordship, the court has gone further, Lordship. The serial number 2, para 36 to 41. Huh? See, (36 to 41), Lordship, take note. I will not read because the same principle was reiterated. And Lordship, it was more than this. Lordship can read from para 366, page 366. It is there. And then Lordship, para 36 at 368. 368.
Yes.
Lordship, this is only one thing, Lordship, in para 37. Seen in the light of the aforesaid settled position of law, we are of the clear view that the fact of the present case, the High Court overstepped in the appellate jurisdiction under Order 43 so-and-so, situated in the view taken. So, the High Court order was set aside, Lordship. The serial number 3, para 10, 15 and 16. at page 124, Lordship. Para 10. 124. Lordship. The trial court gave an interim mandatory injunction directing the respondent number 4 not to continue in possession. Lordship. The trial court gave an interim mandatory injunction directing the respondent number 4 not to continue in possession, as in our case, Lordship. The trial court said, you wash your hand and go out of it. Don't interfere with the possession of the defendant number 2 in future, till the disposal of the suit. There could be no doubt that the court can grant such intellectual mandatory injunction in certain special circumstances. It would be very useful to refer to some of the English cases in so-and-so versus so-and-so. All this is referred. Then Lordship, para 10, then para 15, all these various cases have been referred, Lordship. And Lordship will read. It is similar to our case, Lordship. Most of the facts, Lordship, are similar to our case. Para 15, Lordship. No, para 15. May I read, Lordship? Para 15, page 126, Lordship. May I read?
Yes.
Lordship, I will not read the whole thing because some judgments were referred. Then it is the 10th line from the bottom. It was further held that the court should consider to where the balance of convenience lies and whether it is desirable that the status quo should be maintained. Lordship, get it? It is line about in the para 15, it is line about 10
Yes, yes, I
from
have
the book.
already.
The placitum is also not there.
Yes, yes, I have already.
Lordship, get it? It is further held that whether it is desirable that the status quo should be maintained. While accepting that it is not possible to say that in no circumstances will the Court of India have any jurisdiction to issue an interim injunction of a mandatory character in so-and-so versus so-and-so. A division bench was of the view that if the mandatory injunction is granted at all on the intellectual, it is granted only to restore the status quo and not granted to establish a new state of thing differing from the state which existed at the date of the suit was instituted. Lordship will take note. I am not going anywhere, Lordship. On the date when the suit was instituted, para 30, para 31, and the prayer 7 at page 95, para 30, 31 at page 90, 92 and 91. Reading this, Lordship, Supreme Court is very clear. What the court can do and what the court should do. The next page, Lordship, next paragraph I am reading, Lordship. Even, Lordship, they have referred to some cases. I will read their paragraphs. The Supreme Court say other way around. It is in my favor, Lordship. I will read the paragraph from their judgment, Lordship. The relief in para 16, Lordship. The relief of intellectual mandatory injunction are thus granted generally to preserve or restore the status quo of the last non-contested status. Lordship, get it? Which proceeded the pending controversy until the final hearing when the full relief may be granted, as in our case, Lordship. The trial court has decided that till the suit is finally decided. And to compel the undoing those acts that have been illegally done. Lordship will take note. It's a similar fact, Lordship. Lordship, sometimes God help, Lordship. Some poor advocates also sometimes get this type of hearings. We are getting lost. We have been out from the everywhere, Lordship. We have been knocked down from the ring of the boxing, Lordship. We have out. The hearing, when the full relief may be granted or to compel the undoing of those acts that have been illegally done or the restoration of that which was wrongfully taken from party complaining. But since the granting of such an injunction to a party who fails or would fail to establish his right at the trial may cause great injustice or irreparable harm to the party against whom it was granted, or alternatively not granting of it of a party who succeeded or would succeed may equally cause great injustice or irreparable harm. Court have used certain guidelines. Generally started the guidelines are. This is 1, 2, 3. So this is my second year. Now Lordship, the 4. I have read the 3, na? It is 4. I have read. The 4, I will not read the same thing, Lordship. It is the guideline and all these things. The register sale date presumption and all that, Lordship will give. There are 31, 36, and 38, Lordship. If there is a registered sale date, it is otherwise also 114, Lordship presumption is always there in favor, Lordship. Then, Lordship, serial number 5. Serial number 5, para 15.2.4. Page भी नहीं है इसमें. Internal page 17, Lordship. 7. I know.
No, I have already found 15.
Yes, page is on the top, Lordship, where the SCC online web edition is written. Para page 17. Yes. 15.2.4. Further, the respondents are not in possession of the property, where the appellant possession since 1905 is admitted in the plaint itself, as in our case, Lordship. In the plaint, there is an admission, Lordship. In such circumstances, where the plaintiff are not in possession and the defendant is in the settled possession over a century. Now, in my case, it's not century, Lordship. It's from 2008, Lordship. And the defendant is in settled position for over a century. A suit for a bare injunction by a proposed transferee is clearly not maintainable. Section 41J of the Specific Relief Act prohibits grant of injunction when the plaintiff has no personal interest in the matter, as in our case, Lordship. What right he has, Lordship? Sale deed is not there, nowhere. And I have to read further. Huh? I have to read further. Yes. In the present case, the respondent, being mere agreement holder, have no personal interest in the suit scheduled property that can be enforced against the third party. The personal right, as when there is bar in law, the mere existence of an interest in the outcome cannot be given a right to sue. Lordship, in the probate case, Lordship, Assamese, there is a saying, Lordship, Gosot Kutha Lothot Tel. It's like that only, Lordship, nothing else. But at law, the mere existence of an interest, the outcome cannot be given a right to sue. As held by us above, no declaratory relief has been sought, as in our case also. As held by the above, no declaratory relief has been sought, as contemplated under Section 34 of the Specific Relief Act 1963. So my case, on the first day itself, Lordship, I say Section 34 have to comply with the proviso law. It is not, suit is not maintainable. I do not know why, Lordship. I am not there earlier. Now I have suggested file an application under Order 7 Rule 11. If they have not paid me money, Lordship, I have given advice, Lordship. It should have been long back, it is decided, Lordship. It is not maintainable, Lordship, this suit. So this is, he knows, my Lord, he knows very well, because he is filing this type of petition day in, day out there. He knows. Now, Lordship, the 6. 6, I'll read only one paragraph, Lordship, para 36. I'm very precise, Lordship, because reading all the fact and Lordship, it will take time, Lordship. Para 36. That is. 7. Where? 796, Lordship, page 796.
Yes.
Para 36, Lordship. Because all the facts and ye was narrated, Lordship, in the top. Then para 36. In the factual background, for the plaintiff to succeed, she has to establish this, she has a legal title to the scheduled property. Schedule A property, as in our case, Lordship. And consequently, is entitled to a decree of possession. The defendant cannot be dispossessed unless the plaintiff has established a better title and right over the Schedule A property. Showing masul power, Lordship, nobody can do this when the matter is pending before the court. And lease pendants, I will show, Lordship, what is lease pendants, Lordship. That the lease pendants also, Lordship, are good, Lordship, I'll show. They, from theirs has been only, I'll read. So, I think that must, no? So that must, Lordship. Para 36, I can read the whole, Lordship. No point, Lordship, reading all. Then 7, Lordship. Paragraph 15 and 19. Paragraph 15 is at page. It may not. It is regarding conduct of parties, Lordship. Lordship will see this. I will not read it. It is regarding conduct of parties, Lordship. When the matter is pending, Lordship can look into the conduct of parties also. Now, all these are conduct of parties, no? Or the 7, 8, 9 is conduct of parties, Lordship. I will not read all this, Lordship. It will take some time. And Lordship, competition, separately, competition, competition, huh? On India, will no go. It should be to cope again. I don't know to decimal. Para 22.5. Lordship, this is a judgment passed by Honorable Justice Ujjal Bhuiyan and Kulyan Rai Surana, Lordship, of this court, Honorable Court, Lordship. Page 327.
Yes.
Para 22.5. Page 327. That the must has been read, Lordship, from the affair, from the DCP crime, all that, just to bias the court, Lordship. Nothing. They know after the High Court orders, this is nowhere, Lordship. But still, what is the position of affair? Let me show, Lordship, on para 22. Does because I have read the first line, first word of the affair subject, land grabbing. Now, Lordship, if the land grabbing affair is there before the police station, and I'm not telling them police officer, my lord, whoever is there, they must see the land grabbing act. Now, let us see 22.5. Thus, if the provisions of section 7, 8, 11, 12 of 2000 Acts are read in conjunction, what emerges in this case of an offense of land grabbing and the related offense as described in section 5 of 2000 Act, the authority competent to inquire into the and try the offense of land grabbing is the special tribunal.
Here in Assam, the special tribunal are the additional district.
Yes, Lordship. It is there. Now, it is for the special tribunal to frame charges and thereafter try all offences punishable under 2010 Act. Going by the language of section 12, if any case involving any act of land grabbing was pending before the police, or other investigating agency at the commencement of 2010 Act, such cases would stand transferred to the jurisdictional special tribunal. Having regard to the non-obstant clause of employ in subsection 4, the section 8 of 2010 Act, it is evident then where it is case of land grabbing, exclusive jurisdiction is vested in the special tribunal. In such a scenario, role of the police or any investigation agency. My lord, let me read for my own satisfaction, lordship. In such scenario, role of the police or any investigation agency is ruled out. Therefore, answer to the part of question to our mind does not arise at all. I'll send a copy to Vorolmo police station. Let them read. Lordship, now this is there is another index, Lordship, of the upper IA, Lordship. Lordship, no, Lordship, they, at the cost of repetition, I'm reading 100 times, Lordship has read that skipper construction. At page 635. Page 635.
Yes.
There is a separate line, Lordship, in between. The contemner should not be allowed to enjoy or retain the fruit of the contempt. Now, much has been said, Lordship, that the Order 39 Rule 2A at this stage is not maintainable already. I am 151 even, Lordship. What the Lordship can do and what Lordship should do after looking at all these facts. Para 17. The principle that a contemner ought not to be permitted to enjoy and to keep the fruit of his contempt, it is well settled. In so-and-so versus so-and-so discord held, clearly, that undergoing the punishment for contempt does not mean that the court is not entitled to give appropriate direction for remedifying and rectifying the things done in violation of its order. The petitioner therein had given an undertaking to the Bombay High Court. They acted in the breach of it. The learned single judge held them guilty of contempt and imposed a sentence of 1 month and so and so. Then it was contended before the court that the learned judge was not justified in giving aforesaid direction in addition to punishing the petitioner for contempt of the court. The argument was rejected, holding that the single judge was quite right in giving the appropriate direction to close the breach and the undertaking. Then Lordship, para 19 at page 636. Lordship,
yes.
I'll skip the first 4 lines because so many cases has been referred. Then the court come to the Madras High Court that where an act is done in violation of an order of stay or injunction, it is the duty of the court as a policy to set the wrong right and not allow the perpetuation of the wrongdoing. The inherent power of the court, Lordship, it is inherent power, Lordship, 151, our application, Lordship. The inherent power of the court, it was held, is not only available in such cases, but it is bound to exercise it to undo the wrong in the interest of justice. There was a case where a meeting was held contrary to the order of the injunction. The court refused to recognize that holding meeting is a legal one. It put back the parties to the same position, Lordship, I am here on. It put back the parties in the same position as they stood immediately prior to the service of the interim order. That my interim order was. That's the duty of the court law. Then Lordship, para 20, I'll skip. Para 21. I can skip the para 21 also, I don't think, Lordship. It is no doubt that the statutory rule and the appliances given to effective court is necessary by overruling the procedural other technical objection, Lordship. What they are saying, Lordship, all these technical things. Oh, Supreme Court said, no, look, don't go to the technical. It's the handmaid of justice. The court should go beyond that. Then Lordship, the number 2 is the Sujit Pal, is 1986 Calcutta. It is a division bench Lordship. It is.
Is from Calcutta High Court.
Because Lordship, the Supreme Court relied on this judgment, so I have read this judgment, Lordship. It's a liberal and so nicely written, Lordship. Because the Calcutta High Court, sometime in the civil side, Lordship, instead I have seen Calcutta High Court and Madras High Court, Lordship, from ILR, Lordship.
Yes.
The language are so nicely they have written, Lordship. Very short, precise, but directly to the point, Lordship. Lordship, it is, I will rely on para 8, 11, 13 and 14. Lordship, you can take note. This Calcutta judgment, I will rely para 8, 11, 13 and 14. The fact is similar to somewhat here because it is a temporary mandatory injunction, Lordship. That Lordship will get in the first paragraph itself. The opposite party for a temporary mandatory injunction, Lordship, it is there in the first paragraph itself, Lordship. Then Lordship, in paragraph 3, last line, Lordship will get forcibly disposes the opposite party from the suit premises. Lordship, get it? Her paragraph 3, last line,
Yes.
is in our case, Lordship. Then paragraph 4, the court said that under section 151, if not the order 39 rule 2A, 151 has allowed the applicant for temporary mandatory injunction directing the restoration of possession of the opposite party of the said room and the said premises with the police help. That's why I'm reading this, Lordship. Then I'll come to para 8. It may be that of order 39 rule 2A is in the nature of execution proceeding. But the question before us is whether the court has inherent power to grant temporary mandatory injunction for the purpose of granting relief to a person who has been dispossessed despite an order of interim injunction. Lordship, as in our. Now the answer. In the instant case, there is no question of execution of the order of interim injunction that was granted in favor of the opposite party, restraining the defendant, including the petitioner, from interfering in the position of the opposite party, the room in question. The petitioner was forcibly dispossessed the opposite party from the room and has taken possession thereof in utter violation of the interim injunction. If the opposite party is urged to pursue the remedy under so-and-so, it will be doing a great injustice to him, is as much as said provision the court cannot grant immediate relief to the opposite party. So there is no question of execution of the order of interim injunction. The real question is granting of immediate relief to the opposite party by restoring possession of the room. I said the immediate relief. What I am on, Lordship, it is the immediate relief. How the court can give immediate relief, Lordship. The analogy of Order 21, Rule 32 of Civil Procedure Code, in our opinion, has no manner of application for the purpose of granting relief to the opposite party because filing a execution and all that of the injunction, Lordship. Order 21, Rule 32. We do not also think that there is any relevance of considering the applicability of the provisions of Section 51 of the Civil Procedure Code, which relates to the power of the court to enforce the execution. The injury is grave and serious. Lordship will take note, as in our case, Lordship. The injury is grave and serious, and sub-justice demand that the court should at once take steps in granting relief to the opposite party. In this connection, we may refer to an observation from Karen Injunction, that 6th edition, at page 41. But where the injury is so serious or material in character that the restoring thing to the former condition is the only remedy which will meet the requirement of the case, or the defendant has been guilty of short practice or unfair conduct, or has shown a desire to steal, immerse upon the plaintiff, or to evade the jurisdiction of the court, the injunction will issue notwithstanding the amount of inconvenience of the other party, and though the expense thereby caused to him will be out of proportion to the any advantage of the plaintiff may derive from it, right? And then what next? Next paragraph is 11. Next paragraph is 11, para 11. What? Thus, it is apparent from the said observation of the Supreme Court that no technicality and the prevention. I have read this, no? No? Thus, it is apparent from the above observation Supreme Court that no technicality can prevent it from doing justice to an excess of the inherent power. Order 39 Rule 2 lays down a punitive measure for the purpose of compelling a party to comply with the order of injunction. The process, as contemplated by this provision, may or may not be ultimately effective, but in any event, the procedure laid down in Order 39 Rule 2A is incapable of granting an immediate relief to party who has been in forcible disposals in violation of the order of injunction. We do not think that in such a case the court is powerless to grant relief to the aggrieved party in exercise of the inherent power. The very object of Order 39 Rule 2 has been enacted to fulfill the grant of temporary mandatory injunction and restoration of possession to the aggrieved party. The inherent power of the court, as recognized under Section 151 of the Code, is an addition to the power conferred on the court under the provisions of the Code. All that the court is concerned is to prevent abuse the process of the court and to do justice by immediately intervening under the circumstances which request such intervention by the court. And we need that. That is why we have filed the miscase laws. Our miscase is there. Then lordship.
Mr. Afridi, I just want to tell you one thing. On that day, you made your submission basically on FAO.
Yes, sir.
There are definitely one civil was also filed
Yes.
regarding the violation of so and so.
Yes.
So Mr. Sharma has already placed
Yes.
his argument on that regard.
Yes.
So if anything is to be placed, then it can be placed.
Yes, yes.
Because on that day you are strict to this
This
submission
FAO was filed
mainly on
by us.
FAO only.
Yes.
So, but the other cases was
The
also pending.
violation application was filed by the respondent.
Yes, respondents. That's what I'm saying. They have submitted in that regard.
Yes, yes.
So,
And they have filed their objection.
you have already filed your objection.
Yes.
Of that regard, you can submit it.
Yes. And in the order, it is very clear, lordship, that it will be finally disposed of.
Yes.
Pardon?
It is finally disposed of. It will be finally disposed of. Both
Yes,
is-
yes.
It is there in the order.
Uh-huh.
So, lordship, next paragraph is para 13. In so-and-so versus so-and-so, the Allahabad High Court has taken the same view as above, and namely that when a party has been dispossessed in disobedience of the order of injunction, the court can, in exercise of inherent power, of pass such order for the ends of justice as will undo the wrong done to the aggrieved party. So this is paragraph. Lordship.
We'll do one thing.
Yes.
Because we have a meeting,
Lordship,
full court meeting. So
any date.
we will continue from this only.
Only
Now
only
there are
minutes.
other some judgments, but basically on that point, I think that this if
Only
it-
2 3 are earlier, very few, 15 minutes, Lordship, 15 to 20 minutes.
15 minutes.
Not today, Lordship. Lordship was meeting, Lordship. Any day, any day.
Because there are 1, 2, 6 or 7 more cases are there.
Yes.
But basically, I just want to ask you. Basically, all these
Only 5,
these
6, 7
citations-
I'll read. Not,
no,
not.
all these citations, basically on this point only.
Yes, yes.
That for the
Duty of the court for
for
rectifying the
restoration of
thing when
position by
the
this court.
matter is pending before the court and the what the court to do.
Yes.
And when the police help, Lordship, the last is serial number 7 is the police help.
Regarding the police help.
8, 9,
If
10.
it is required, the police help is.
Yes, if required, to police.
So anyway, if you want to make submission in that regard, so we'll hear to it. No issue at all. Because I have some work in the chamber, and then 4:15 the meeting will start at about 4:25.
Lordship, any day.
So that's why I think. When it can be, yes, can you tell us any convenient date for you? We have to Match it up because I'm taking the
18.
criminal bench now.
18,
That
no?
purpose, I'm just listing it at 2 p.m. So that it can help you. Otherwise,
18 Lordship.
pardon? Which date?
18.
1-8. Hearing date. It's not a hearing. Please tell us a hearing day.
Yes, I read
It's not a hearing
17
day.
or 19 Lordship. 17 is fine.
17 is a Tuesday.
Yes. Yes.
Tuesday.
17 is
We hearing the fixed question.
fine.
Itu nah ya. Nah, amat nah. Asal itu order dulu. PM পড়ায় আমার পিকচার হচ্ছে একটু PM পড়াই দিয়ে আপনি একটা ইনস্ট্রাকশন দিব list numbers of methods so that method can be taken away এটু হলে মানে সুবিধা if it is on 17 হলে it is a Tuesday. It's a Tuesday.
Lordship, we have no problem. Convenience to the court, Lordship. It is the.
Because no, I'm just at present I'm taking the criminal bench.
I know.
So I have to accommodate these things.
No, Lordship, I know. So
So
it is the court convenience, Lordship. I'm here.
today somehow we managed.
Lordship,
We
it is the court
completed the
convenience.
entire list by 1
Yes, Lordship.
somehow.
I know.
And so that it can be heard. So that's what I'm just asking him. That we'll have to ask the registry to put less amount of 55, 56 matters have been fixed.
17 and 19
another
any
problem.
convenient.
So 17 we are going to fix it 17. Subject to we are will make a request to the registry to list numbers of other criminal matters so that it can be heard. In that case, you're also convenient.
Yes, 17. No.
17th at 2 p.m. At 2 p.m. only.
Yes, Lord.
At 2
I'm grateful.
Also status quo order.
Yes.
Interim order pass.
Sit agor order mate hoye jaba. Status quo order. Please. It was 20, na? 20-0. As per you, the status quo order was
26-11. 26-11.
20.
6-11.
No.
No, that is the hour.
That is the first order. Last order is there only. 21. Not 26. 20. It was on last
January
20th
20
of January,
Lordship.
I think.
201, 28th of January. Lord.
Itu mode di.
Referring to 26-11. Lord. Yes, Lordship, I'm very correct, Lordship. 28th of January, where Lordship has said that 26-11.
Order with 6-2 এর order হয়েছে আর 2-2 এর order হয়েছে 6-2 মত মাইটেন that's is absent today stuff for it
20 28 no 20
yeah 20 2001
yes
2026
yes.
in ISO and so
Yes,
it is